we had the long session and he made it easier. If I had known that he was going to take that attitude, I would not even have addressed it. He made it clear that that was not his issue at all. In fact, he himself, short of testifying, was satisfied that that issue was not, or rather that the so-called diagnosis was mistaken, for lack of a better word. Now, that makes my task much easier today because I will simply zoom into the issues, the Section 65(4) issues which are before you. Now, fortunately, my learned friend and I don't know which judge found me which way. So we might have decided that for afterwards. But it really is, it doesn't matter. I just want to say maybe this, in case I don't get another opportunity, that we are, it's something to be welcome. You know, so often in our courts, particularly the full courts, there's sometimes unanimity that just happens, and sometimes it's worrisome. Unlike in the SCA and other courts where there's a culture of dissent, which is a good thing in our system, and I think the public should know that that's it's as it should be, that judges follow what they believe to be correct. So I'm simply saying it doesn't really matter for us which judge found which way. Save, of course, to the extent that we might want to address particular concerns, which I'm sure will be raised from the judge. Now, I start deliberative examination in Section 65(4) because that really is what brings us here. This is an appeal in terms of that section. And it has been said in our courts that despite its wording, actually there's nothing magical about Section 65(4). It's an appeal like any other appeal. And the test is now well established. And it has been well articulated in some of our courts. And that test was more recently articulated in the case of Zandile that we dealt with last time. It's Zandile versus S. The version I have is 2020 JOL 47205. I think there's also an SAC reference to judgment of Justice Freedom in the Carter. And he put it very simply at paragraph 13 of the judgment. He said, I am of the view that this court can only conclude that the court of law was wrong if it considers all the relevant aspects for and against the granting of bail to the appellant. If this court then is of the view that the court in light of all these circumstances, should have granted bail to the appellant, the only conclusion would then be that the court of law decision was wrong. So it's the single test of wrongness, the word that is used in 65(4). But I want to emphasize some of the words that are in that quotation, which is that the task of the court is to consider the circumstances for and against granting of bail in a particular case. Now, that's very important in this particular case for a reason that I'll come to later. which we canvassed extensively the last time. The court will remember, at least the members of the court who were here before, will remember that the learned magistrate fortunately had played open cards in that it was clear what was the central issue that concerned her. And we demonstrated, hopefully, and we will demonstrate again today, that that basis, in other words, if you use the straight on J formulation, the facts against the grant of pay, we will hopefully demonstrate today more than adequately that that basis was wrong. Now, if we can succeed just in that, on that narrow aspect of analyzing that judgment and then hopefully successfully convincing the court that that was a wrongfully decided decision on what I will identify as the key point, then that should be the end of the matter as far as Section 65(4) is concerned. Because that's the test, that's the undisputable or undisputed test. And fortunately, if you looked at the heads, both my learned friend and I, we agree on the test. We agree on the basic principles. Even when I had
Senior counsel in the Zandile Mafe bail application, his second attempt, and we'll see later.
When we stood up, said no, we agreed on that as well. So we agreed on the broad, we agreed on Zamini, we agreed on Atchison, we agreed on the test. So there are no issues there. So the issue really becomes an inspection of the reasoning of the learned magistrate. Now, I just want to dispel a few fallacies about just the legal test, because it's a bit nuanced and sometimes it's confusing, at least to me. But I thought what I should do is to say the proverbial, where do we start? I think the best place to start, my lady and my lords, is the Constitution of our country. And you will see that that is the basis upon which our heads were premised. The preamble to our heads on page 1 is a very important start, and that's the quotation from Professor Atchison that my learned friend and I agree on.
Yes.
And it's quite a simple statement. It says, an accused person cannot be kept in detention pending his trial as a form of anticipatory punishment. In other words, just because there is a serious crime or there's an outcry and all that. And a reference to that, the case that I'll talk about, S versus Mohammed, which happened in this case, in this court, where the accused was a member of Pagat. There was at that time a rule thing about Pagat. And the court said, irrespective, obviously this is a big thing against terrorism and all that, but an accused person must be not kept in detention as some form of anticipatory punishment, as Mohammed H.A. said in Atchison. He goes on to say, the presumption of the law is that he is innocent until his guilt has been established in court. The court will therefore ordinarily grant bail to an accused person unless this is likely to prejudice the ends of justice. Unless this is likely to prejudice the ends of justice. So that formulation alone weighs in favor of an accused person. Now, the confusion I was talking about, which one has to almost grapple with, is that on the one hand, everyone accepts, and I know this court, I don't have to convert this court. I know that it accepts that we are all entitled to our freedom. There's no difference between me and someone else just because they happen to be arrested. I'm entitled to go and sleep at home, and so is he or she. So that goes without saying. But what usually muddies the water is this issue of the formulation of section 6011A regarding the owners. Because that, and our courts have grappled with this for a long time. As one of the judges said, I don't want to try the way constitutional eagles there in trying to define what is exceptional circumstances. But I'm going to illustrate that that actually is a problem which should not exist. So, for good reasons, at least according to S versus Lamini, which I don't quite subscribe to for various other unimportant reasons. But according to S versus Lamini, remember S versus Lamini was whether or not that section is constitutional, or does it encroach too much into the presumption of innocence, the stuff that we all know. And one of the reasons that the Constitutional Court found that the section was not unconstitutional was exactly because, again, of something which should be simple. There is nothing wrong at face value in the law differentiating between a range of offenses. Surely, it can't be that it should be as easy for someone to get paid for a traffic offense as it is for mass murder or whatever. That's just common sense. But, and this is a big but, that should never be allowed to interfere with the constitutional rights of an accused person. If there's one thing I want to say today, it is that. Why do I say that? Firstly, just as lawyers, instinctively, we know, or we should know, that a statute, by definition, is something of a lower order than the Constitution. That's, again, just common sense. One doesn't need to quote authority for that. In other words, it can never be that a statute, whether it's constitutional or not constitutional, and that's the case of Hande versus the minister or something. Again, it's a child's principle that if you take a statute to court and you say it's unconstitutional, the court will do two things. One, it will say, yes, it's constitutional or it's unconstitutional. But before it does that, because the Constitutional Court at least is not predisposed to just striking out legislation left, right, and center. So the first thing that the Hande test does is that firstly the court must try to construe that statute in such a way that it is consistent with the Constitution. Only if it fails in doing that, then it can strike it off. That's a very important legal principle. And that legal principle is based on what I'm saying now, namely that the tail cannot wag the dog. So the statute, whatever it comes from, cannot change the constitutional position. What is the constitutional position? The constitutional position, my lords, is that a human being, anybody, has a head start. They start with an advantage. Why? Simply because we're in the Constitution. Really, for no other reason. And what is that head start? That head start is actually multiple head starts. I mean, if it was a real race, literally, you'd have the other person having so many head starts that it's going to be difficult to win against that. It reminds me of an analogy that where they say those who have this must stand in front and so on until the advantaged only remain at the back. Now, or rather the disadvantage. So, what are these advantages that any of us have? The first one is that you have a right, all of us, in terms of Section 35(2)(d), to challenge any detention. That's a right that we have in terms of yes, 35(2)(d). Everyone who is detained, including every sentenced prisoner, has a right to challenge the lawfulness of the detention in person before a court, and if the detention is unlawful, to be released. So the right of being released from detention. And that stems from the second advantage, inherent advantage that we all have, which is to be found in Section 12(1). And I'll refer to that, Section 12(1) of the Constitution, which, as we all know, says that every person has a right, not to be deprived of freedom arbitrarily without just cause, and not to be detained without trial. Inherent right. So before we open our mouth, we already have those inherent advantages. And Van der Berg was probably the leading authority in South Africa on bail. Interestingly, has this to say about the implications of 12(1). Page 32.
Page?
33. That's the third edition of Van der Berg. And he addresses kills two birds with one stone. One is this thing about the public concerns and so on, which we know should not be or rather should not be overemphasized. He says, what is particularly disturbing about the quoted passage is that the court appears, in S. appears to have lost sight of the operation of the presumption of innocence at the pre-trial stage, while elsewhere in the judgment it appears to give due recognition to the presumption. And I'll talk about that. That's the third advantage. The distinct impression stated that as the arrest and detention of a suspect on mere allegations may appease the public, a blind eye may be turned to the possibility that the suspect may be the wrong person and therefore innocent. Appeasing the public cannot be logically equated with upholding the interests of justice or even of society. And here's the crucial part. Some may indeed think that the purported distinction between detention without trial and detention in anticipation of a proper trial is in the context of the rights to liberty and to be presumed innocent, mere sophistry, and with respect, disingenuous. So what the author is saying here is that one of the purposes, or probably the primary purpose, of Section 12 was exactly to do away with the obnoxious system of detention without trial. And that, therefore, instinctively, our courts should lean in favor of, or rather, against pre-trial detention, whatever you call it. Very important. So that's a crucial advantage. The third advantage which we have before we open our mouth is the presumption of innocence, which, by the way, is the cornerstone of what Mohammed CJ or AJ, as he was then, said in Ashes. Now, again, the presumption of innocence is not something to be taken, just to be paid service to. It's really a presumption. Presumption, as we know in law, is something to be overcome. It's a favor. You already have the law just gives you a favor, and the other side has to overcome. That's just the classical definition of a presumption, any presumption. So the presumption of innocence is something that plays a crucial role in bail proceedings.
Crucial role. A crucial role.
Crucial role. It's actually it's at the center of the whole thing. Because remember, my lady, that you are, as I say, because these are rights that are given to you by the Constitution per se, just because you are a human being. So you already come with them to any courtroom. You are armed with them because they were given to us, all of us, by the founding mothers and fathers of the Constitution.
There are judgments in other divisions that seems to suggest that it is not a pre-trial right.
Yes.
Do I understand you correctly to be urging us to depart from that thinking?
Yes.
I'm saying so because I've also recently come across a decision in this division that seems to accord with those decisions.
Yes. No, Justice Sula, you're quite right. In fact, the distinction that is usually made is that it's not a fair trial right, which is a fair comment to me. In other words, some of these rights, it is argued by those people, is that well, the rights in 35 are fair trial rights. And because we know that bail proceedings are not...
They are pre-trial.
Absolutely.
Yes.
They're not, strictly speaking, a trial. But with the greatest respect, and I addressed this in the last time, that's a distinction without a difference.
I see.
Yes, because the constitutional rights that we have, and this point will be clear just now when I talk about Section 35(5) of the Constitution. These are rights that we have, as it were, as I say, automatically. So the burden is on the other side, so to speak, to say that they should be deprived from it. Let me quickly illustrate this, if you allow me, Justice Tulara, by moving to what I call the fourth advantage that everybody has, which is more relevant in this particular case. The fourth advantage is that Section 35(5) of the Constitution, which says that you evidence that has been obtained unlawfully may not be accepted. And this is where the distinction is made clear. It says in a trial, or if you make the trial unfair, or to undermine the administration of justice. Crucial. That last part is always forgotten. So people will say, oh, well, it's not a trial, therefore you can't look at a confession or you can do hearsay or whatever. But they forget that that section gives us a right about the administration of justice. In other words, what I'm saying, Justice, in response to yes, of course, all of us know that bail proceedings are sui generis. They are not trial or they are not criminal proceedings. But there are still court proceedings. That's the issue that gets forgotten. And any court proceedings must conform with the Constitution. And therefore you can't simply say, as I will argue now, Well, I have a confession, but since this is not a trial, I can just sort of admit it or take it into account, even if, and I'm exaggerating for effect, even if I have a picture of the peace officer taking money from the investigating officer. I'm just making an outrageous.
But surely the bail court is not well equipped to deal with the admissibility thereof.
No, yes, I agree with that. But all I'm saying is that you're 100% right. So because you haven't had a trial within a trial and so on in terms of Section 207, granted. But what I'm saying is that that fact, which is well accepted, can never deprive a court of law from considering the implications. As I said, that's why I was making this outrageous example of, let's say we have a picture. I say, here's a picture. This peace officer took a bribe from the investigating officer, or they held the mouth of the accused. Surely, any court of law faced with Section 35.5 will say, yes, I know this is in terms of Section 217, I may not look at it, but it would be a violence against the administration of justice for me to give any weight to this so-called, whatever it's called, even if it's called a confession or an admission, doesn't matter. So I'm making a simple point that courts of law still have an overall responsibility to enforce the Constitution. So in an extreme situation such as the one we have here, then those factors should be taken into account. So that's the fourth example. I mean, rather, the fourth advantage.
So what should the bail court do when it's faced with a confession?
Yes.
What should it do?
Yes. Well, what it should do, and that's also covered here, is to do, as I say, firstly, what any court would do faced with a blatant situation. And I'll demonstrate my way just now that this is that example where there's just a blatant. No court could ever accept this thing as even a confession. And I'll come to that now. Maybe let me get to it now since you've raised it now. What do we have here? We have, under Section 217, we know what a confession is. This is just a lawyer's dictionary. We say a confession is a document that has been attested to by a person freely and voluntarily in their sober senses, which admits all the elements of the crime. That's broad definition of what is a confession. 3 important things. Sound and sober senses voluntarily admits all the elements. Okay. So let's just go at that basic level. If we go to a first-year student and you give them this document at page 125, then the most important thing they will tell you is that it is not a confession to start with. It fails all those 3 tests. On the common cause facts, my learned friend again, to his credit, admits that the so-called diagnosis might have been, I don't want to overstate what is it, might not have been the best in the world. Let's just say that. Now, my lady, and this is a point we made, how can the same state say this person is not of sound mind to the extent that we have a diagnosis to it? But that very same state says that that person is capable of doing a confession. And that's just one, not even being a lawyer, it just offends anybody's sense of justice. Because you yourself, you are saying in the same breath that this person is not of sound and sober senses, But you drag that very same person, the patient, you drag them to do a confession. So that's number one. That's the sound and so far. So it fails that test. The second one is that you have evidence from the appellant, so accused, under oath, which says that I was induced to make this statement by some promise which turned out to be false. You'll remember that. So it fails that test as well, the second test. So forget about the swab and so forth. He says, under oath, I was induced to make this statement. And when the state is given an opportunity, you remember in the bail application and the review application, to refute those statements under oath as well, they don't. Crucial. They don't say, no, add paragraph, this, you are making this up, it's not true. So the bail court is now faced with that reality, and this was presented to the learned magistrate to say, here, you remember from the record, when we started on the 29th of January, he said, here's an affidavit. However, this affidavit incorporates the other affidavits in the High Court and so on, and the answers thereto. And that was exactly for this reason. It was to show that there is, at that stage, unrefuted evidence that the statement was not voluntarily made. Okay? So that's the phase of the second test. Then the third test, which is the one that should kill the whole thing, is that a confession, as you know, by definition, is a statement that admits the elements of the crime. The courts are very strict with this one, for good reason. To the extent that, to a non-lawyer, the imagine think this is ridiculous. Because I can say, maybe in a so-called confession, I killed Mr. God. And the court would still say, no, that's not a confession. Because a confession must be an admission to all the elements of the crime. As I said, to a lay person, that sounds like crazy. Here's a person saying, I killed so-and-so, and you're telling me that they're not confessing. But the good reason for that is that the court, you know, my lady, well, these rules, even those that look outrageous, we must always remember they are there to protect all of us. It's not to protect that particular accused person who might have killed someone and so on. These rules are there to protect society per se. And so, if you look at page 125, you see that, and I think at least we agreed on this with the previous talk, is that the thing is not, cannot by any description be called a confession. I mean, nowhere, it literally doesn't admit to anything. It was a right thing to put the parliament on fire, to burn the parliament, because at the moment it does not work for people as previously. No services, no jobs as previously, and so on. The people in charge don't care because it belongs to tycoons who enrich themselves at the expense of government. Now, let's look at that. In which world can that ever be called a confession? Where the person doesn't say anything, quite literally, anything about them. They don't say, I did this, or I did not do that. They don't even go to say, that's just the actus reus. Forget about mens rea, forget about lawfulness, forget about all these other things. So there's not even one element that is admitted. So with the greatest respect, it's just not a confession. Even, I'm sorry,
No, it's okay. I'm sorry to interrupt. What about the affidavit of Colonel Ferrer, who says he admitted to me, and pursuant to that, I then said, let's do this.
Yes. No, that affidavit, there's a different problem with it. One, we say, and I think the learned magistrate also accepted that. Firstly, the problem is the one that I've already mentioned, that when the opportunity for the state to refuse this happened, they didn't. And that would have been the fairest way to do it. Where there's an affidavit, you have a chance to do an affidavit, and there's a reply affidavit. Actually, for the state, it was lucky because they had 2 bites of that cherry. Remember, they found an affidavit in the bail application, and then we found an affidavit in the review application. Both times, they did not take the opportunity. What then happened, as you correctly pointed out, Madam, is that literally on the day, and you'll see the objections are made, on the day, in the middle of the bail application, we're told that there's this affidavit. We even said, we complained about the so-called medical diagnosis because we said it was produced at the 11th hour. This one was not even at the 11th hour. It was produced after the 12th hour. In the middle of the
in the PMs.
In the PMs, correct. Now, that is a distinct disadvantage. Your leadership knows that one of the key principles in bail applications is that an accused person must be given a fair opportunity to deal with evidence. That's basic. I think that was also said in this court. In Mohammed, what was said is that Mohammed is one of the cases we've cited. From the head note, it says Section 6011A, which is the one we're dealing with here, places an onus on an applicant to adduce evidence in exceptional circumstances. In this regard, the applicant must be afforded a reasonable opportunity of adducing such evidence. As such, the applicant must be furnished with sufficient particularity of the charges and the other information. Now, what that means in simple language is that when you have as you have here, luckily for the accused or the appellant, a situation where there have been opportunities which have not been taken to refute his evidence of so-called inducement. And then it is just sprung up in the PMs, as Justice Tulare correctly points out. Then where is the opportunity for him now? There's no opportunity there and then now to say, no, I didn't, which he would have had in the reply affidavit, remember. And that's just a question of basic fairness. And often, all lawyers know, and I'm sure the bench knows, that when you represent a person for bail, you are always caught in between what might be delaying tactics on the other side, or let's get on with it and just do the bail application. Or the state might say, might just put things like they did to us on the 11th of January. Just throw in some medical certificate. Then what do? Do you continue with the bail application, or do you retreat and let the accused stay even when you know that this is a spurious so-called diagnosis? And we were caught already in that, and that's why we came here to set that thing aside, the diagnosis. So before I digress, so the point I'm simply making is that yes, the leadership is quite correct that the Lieutenant Colonel Tehran makes certain remarks in his statement. But you will see that the record is replete with objections were made on that, on admission of that affidavit. What is worse, and we made this point as well, is that as against the accused person giving viva voce evidence, Lieutenant Colonel Teron, who was in court and made sure that that is reflected in the record, did not give any evidence. So he, unlike the accused person, escaped the rigors of cross-examination or of any refutation of what he says, let alone the fact that it was sprung on us on the last minute. So with the greatest respect, that is not where the paper is written on. Because we know, again, the court knows, that in every case about confessions, the investigating officer always paints the picture that it was all paradise and they were hugging each other on the way to the confession room. But that's the purpose. It goes back to your earlier point, Emily. That's the purpose of the so-called trial within a trial, because half of the time all that is shown to be not true. But here we don't even have the semblance of a trial, within a trial opportunity because of the circumstances. Justice Strickland.
Yes, I just want to be sure if I understand you correctly. The purported admissions that have allegedly been made by the appellant to Lieutenant Colonel Teron, do I understand you correctly that you are saying that the appellant never had an opportunity to challenge Teron as far as that admission is concerned because the affidavit was handed very late? Is that
Yes, it is, but that's not all, Justice Strickland. What I'm saying is that the utterances of Mr.
Teron,
of Lieutenant Colonel Teron,
yes,
can never be, at least in this court, must not be taken as unchallenged. Let me put it that way.
Yeah.
Because firstly, they were challenged a priori. Remember, they were already challenged when the accused says I was induced. That in classical confession law, section 217 for beginners, once the accused challenges any of the elements that are spoken about, then the onus shifts to the state. That would be now in a normal trial, to refute that allegation, so to speak. So what do we really have here? Let's forget the technicalities. We have a situation where an accused person says, I made this thing, I don't know what to call it, a confession. Even the thing itself, whatever you call it, for the purposes of this debate, let's assume it was a confession. We know that this is not. But I was induced, number one. Number two, it's common cause that it is at the time when the state said I'm not compos mentis. It's common cause. And therefore, Colonel Teron has got three mountains actually to climb. And he cannot climb those mountains by surreptitiously sneaking some affidavit in the middle of the proceedings, not coming to the box like the accused person, and then that's it. When there's no opportunity now, unlike in the application proceedings, for the accused to do a replying affidavit, so to speak, because we couldn't very well call him again into the box to now say, because when he testified, we had no clue about what is in Colonel Teron's statement. No clue. And the point is made in the record. Fortunately, I made a point of registering all those points right through. So I think I said something like, a document that's just been given 10 minutes into the proceedings is not worth, and I think the compromise that was reached was that, well, it's going to be referred to provisionally on the basis that it will be supplied to the accused later, which is just... So, So that's the answer to that question, Malene. But again, assume I'm wrong in all that. Assume that Colonel Taron's statement then can be said to refute the second hurdle. The third hurdle, which is that in the first place the thing is not a confession. There's no answer to it. The first hurdle, which is that the person was not of a sober mind, there's no answer to that. So whichever way, remember these three things must all be present. The absence of one of them undermines the so-called confession. Therefore, if for all the three reasons, or two of them, or one of them, doesn't matter, the thing is not a confession, then it comes to the crux of this case, which is that the learned magistrate, with the greatest respect, misrepresented, and I say that with trepidation, misrepresented the import, let's say, or the gist of what was said in the document. I'll use a neutral term. Let's call it a document. Now, that really takes us to the heart of this case. Because remember, 65.4, your task today is a simple one. Your task is to determine whether that decision was wrong. And if I can convince you that it was wrong on this aspect alone, then we will be getting somewhere. I'm still going to come to, when I round off, I'll come to the misunderstandings, to put it literally, of exceptional circumstances on the part of the magistrate. That alone was a fatal error. Not to mention the gross irregularity found by this court. And I made the point to the previous court that the fact that it was two other judges is neither here nor there. It's the same, it's you, it's this judge, this court. So you have found that there was a gross irregularity, not just and a gross irregularity that is related to the question of bail. Not just a gross irregularity somewhere out there. Now, if this court, how can this court, that's what will confuse the public. That how can this court, the same court that says there's a gross irregularity, in the same breath say there are no exceptional circumstances? What is that? Because that gross irregularity goes, if I'm correct, that it's connected to the bail issue. That gross irregularity is not some gross irregularity there. It actually goes to the issues before this court. If I'm correct in that, and I will demonstrate just now that I am, then on that basis alone, forget the confession, forget all these other things I'm saying. The presence of exceptional circumstances, at least as the first step, or ticket to the game, is not cannot be refuted. Now, if I may, I've given a copy of this to my learned friend. I don't need to hand up.
Thank you. This one.
Now, that, I'm handing that judgment up just to illustrate the point I'm making. You'll remember, this is a judgment from the full court here issued by Acting Justice Watan Falcon, if I'm pronouncing that correctly.
Yes, that's correct.
Yes. And this judgment, unfortunately, we debated it, but unfortunately it came 4 days after,
yes.
after we were here, in the same week. But I'll show you the relevance of that to the point that we're debating now. The only point I'm making right now is the fact that the relationship between the irregularity and the bail proceedings. If the court kindly goes to paragraph 16 on page 11, just at the top, from the word furthermore. Furthermore, he selectively entertained the state's application for referral despite the applicant's contestation. And that is against the principle in Newell versus Premier. He, there being the Lieutenant Magistrate, the acting district magistrate, not the general court. In granting the opportunity to present evidence at that stage would have led to no prejudice. At the very least, the magistrate ought to have engaged with the applicant or his counsel to fully apprise himself of the reasons for the opposition. The magistrate did not even acknowledge or greet the applicant. I agree with Mr. Mpofu's contention that the denial of the applicant's rights to rebut or challenge the district surgeon's report, which led to the denial of the applicant's the right to apply for his release on bail, impacted on his constitutional right to be heard fairly. Now, the importance of that is, let's forget the Audi issue, because that was the basis of the finding. But the crucial point is that this court acknowledged that procedural irregularity then impacted on the question of bail, which is the one that's before you. Then they go on to say, the more pertinent issue relates, paragraph 17, sorry. The more pertinent issue relates to the magistrate's election to displace the bail application. Okay. So it related directly to the bail. And I remember this, actually, the reason why I picked this out, I think it was Justice Tulare, in an exchange between me and him, was this question of whether the bail application had an impact, or rather, the gross irregularity had an impact on the bail issue. So the record reflects that the magistrate did not at any stage dignify the applicant's plea to be heard on bail with any response whatsoever, thereby impacting the applicant's right entrenched in the Constitution. And very importantly, you see that footnote at the bottom. It refers to section 12(1) of the Constitution. This was a good cross-reference by that court, because it was tracing the right to bail to one of the advantages I spoke about. Mr. Mafe was entitled to apply for bail. The magistrate made no inquiry into Mr. Mafe's ability to understand the proceedings. In fact, there was nothing preventing the magistrate from proceeding with the bail application. And then it goes on Now, the importance of this in relation to this particular case is that actually irregularity or no irregularity, there was nothing, or rather, the learned magistrate, acting magistrate, should still have allowed the bail application to go ahead. And that is because of a simple principle, that the bail application does not deprive necessarily a person from, or rather the diagnosis, even if it was valid, does not deprive the person of the opportunity to apply for bail. And for that proposition, I will refer the court respectfully to the case of S. Volkman, Volkman, in this division, Hockey AJ, it's 2005, bracket 2, SACR 402, Cape Division, paragraph 16 to 29. Quite a long, ironically, this was also someone who had been referred to Falconder.
Yes.
But I just want to read paragraph 25, which is quite short. It says, in the present matter, we are not dealing with a sentenced prisoner. The accused is still to be tried on a charge of murder and is presently on bail. He has a constitutional right to be presumed innocent in addition to his right to human dignity. And the point there was that even though he had been diagnosed, there was something about whether he should go to Falconder during the day or during the night or whatever. But the gist of the point I'm making is that the mere fact that someone has been referred to Falconder for a diagnosis did not deprive them of the opportunity to be out on bail, which again should be is common sense. Because it can be that the mere possibility of you being confined for 30 days at a time, which might even be repeated, can be like a backdoor detention. Now, so that's the first importance of this. The other issue is that the learned magistrate, which is where I was going, if you go to volume 2, page 79.
That's page 182 of the judgment.
182 of the judgment, that's correct.
Thank you.
Yes, at the top. Paginated 79. And this is what we highlighted, that the learned magistrate misread the document, fit for whatever we call it. She says a paragraph against line 15. In this regard, it must be remembered, in the alleged confession, he claims that he will not stop his activity and is clearly willing to risk life and limb for his beliefs as his recent hammer strike has shown. And that sentence is riddled with inaccuracies and misrepresentations, for lack of a better word, with respect. The only good thing is that even the magistrate, as I say, and even my learned friend in his head, couldn't get themselves to calling this a confession. She called it an alleged confession. And so does my learned friend with this in his head. And I don't blame him because it's not. But he says it must be remembered. Remembered by who? Because this has never happened. That in the alleged confession, he claims that he will not stop his activities and is willing to risk life and limb for his beliefs as his recent hammer strike has shown. Firstly, there's no such thing in the so-called confession. He doesn't say that at all. It's just wrong. It's out of respect, I'll call it a misrepresentation. But the second part of the sentence is even worse, because it says the mere fact that the accused at some stage, and it was common cause at that stage that he was no longer on hammer strike, at some stage exercised his right of protest about whatever was showing that he is willing to risk life and limb for his belief as his recent hammer strike has shown. In other words, he was willing to risk his own life and limb, as it were, and therefore he must not be released on bail. I mean, what is that? And apart from the fact that the hammer strike obviously had nothing to do with life and limb, it was a a form of protest, just as someone will be carrying a placard. So that statement, which is at the root of this finding, remember, when all is said and done, my lady and the lords, the sole reason for the learned magistrate not to release the accused is not because she says it's a flight risk or it's going to interfere with witnesses, all the things that we know. The sole reason is this kind of thing, that he's a propensity to do it.
Didn't she say that she could not find that the applicant then proved that there are indeed exceptional circumstances?
Yes, but again she did. But that's the problem with isolating the issue of exceptional circumstances, Malay, and we went through this, is that it's not exceptional circumstances in the air. Our courts have always said that, in fact, it's not even our courts, the section itself, section 6011, which again is often not quoted in full. So I want to yes. Yes. The section we must remember says, Schedule 6, rather, notwithstanding any provision of this Act, when an accused is charged with an offence referred to in Schedule 6, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court that exceptional circumstances exist, which, in the interest of justice, permit for his or her release. In other words, it's not exceptional circumstances that the person is tall or whatever, extraordinary. It must be exceptional circumstances linked to the very issue before the court about the release of the person, which we know the test is interest of justice and so on and so on. Yeah. So that's the linkage between Section 6011A and Section 60(4), which gives us all those things about abscondment and what have you. Now, so therefore, my lady, the answer to your question is this. Yes, the learned magistrate said that. But she was not just saying that in the air. She was saying it because, according to her, it must be remembered that in the alleged confession, he claims that he will not stop his activities and is clearly willing to risk life and limb for his beliefs, as his recent hand strike has shown. So that's the real reason is this one, not the exceptional circumstance thing links to why is she saying that they are rather she's not comfortable, let me put it that way, to put it mildly. And if to demonstrate that, my lady, let's go to page 94. Don't go too far, but we'll come back to 79. The learned magistrate says that against paragraph 10, the applicant confirming what the judge's values of belief in the manifestation of crime of belief, what is contained in the alleged confession, she says again, as a reason given by the applicant as to why he committed the offense charged. I mean, where did that happen? We've already demonstrated now that he never said he committed the offense charged. In the so-called, in what the letter did not say, the so-called confession. It says, she says, this becomes alarming in light of the alleged indication by the applicant according to the information in possession of the state that he would not stop his quest. So what is she doing? What she's doing is to conflate these issues. And that's why I was saying, my lady, this is a shortcut. If I can convince this court that these underlying bases for the finding are incorrect or wrong, then that should be the end of the case. Now, just to further illustrate or finally illustrate, I invite the court to go to page 80.
Of the same judgment.
Yes. Remember, we started at 79. That's 80, which is A183 of the charge pages. Here are clear contradictions now. Of all these statements, we've just seen that he confessed that he committed the offense and that the hammer strike was also a show of dangerousness. But the same magistrate says the applicant indicates, this is against 11, the applicant indicates he has no intention to become involved in crime should he be released on bail, and describes himself as a poor person in the wrong time at the wrong time, probably in the wrong place at the wrong time. Now, this evidence is unrefuted. She doesn't say, he says that he has no intention to become involved in crime, but I find against that or whatever, or that was displaced in cross-examination or whatever. So how can the very same, so this is clearly wrong, with the greatest respect. Because if you are going to condemn this person on the basis of the so-called confession, let's assume for a minute he did say in the confession that he is going to do it again, which we know is not true. Then you can't at the same time make this statement, which is the correct one, by the way, that he's not going to commit another crime. But what is worse, my lady, is look right further down around 20. I has started to show his displeasure with the situation where while incarcerated and indicated is being fed, but not while when he found himself poverty-stricken on the street trying to eke out a living. Now, that was the real reason given by the accused or the appellant under oath. Not because he's a murderous person. He says, I was protesting because I could not take food. When I was in the street, nobody was giving me food. Now, forget about whether that's a good cause or not a good cause. That's not for the court to interpret. The point is that that was the reason, not the one ascribed to him by the magistrate of him being a bloodthirsty person. And then, as if that's not enough, says the learned magistrate says it needs mention that this aspect is clearly no longer relevant, as the evidence from the applicant himself indicates that he's no longer embarking on a hammer strike. So this hammer strike that makes him a bloodthirsty person, according to the learned magistrate, is irrelevant. Really?
And should not have been in the judgment if that was the position.
Absolutely. Thank you, my lord. But in fact, it should not have been in the earlier part as well. Yeah. Maybe this part she could have put because it's effectual. Yeah. But the deduction from this so-called irrelevant part definitely should never have been in the judgment. And that is clearly wrong. And if that is wrong, then as I say, because this is the fundamental basis for her discomfort, which then takes us to the leadership's question about exceptional circumstances specifically. Now, let's assume for now that we are all agreed that this foundational basis of the judgment is wrong. Now, you may say, and legitimately so. But Mr. Mpofu, even if the magistrate was wrong, because you know the cases say, some of the cases at least say that this court is basically seized with the matter. Okay. But Mr. Mpofu, where are the exceptional circumstances? Well, here's, I've already explained the exceptional circumstances around the mere fact that we're here today. The mere fact that I'm here before you. If you read the judgment of this court earlier, is directly linked to this series of events, including these irregularities, the confinement of the person to Falkenberg, and the striking out of order by the court, and so on. Otherwise, we wouldn't be here, all of us. Now, the important person is not all of us, because my learned friend will probably be in court, and I will be in another court, and the learned judges will be in another court. The important person is the accused and the appellant, because that's the reason why that person is here, hypothetically speaking. That is the reason why, and this is what should, as I say, offend every sense of justice in anybody. That a person has been sitting for 5 months, on Thursday it's going to be 5 months, 5 months in custody. All because the system, quite frankly, is just not functioning in this area. And the system, the very system that made sure that when he appeared on the 4th, he was not told. He was not told about the confession. We know this. These are irrefutable facts. When he appeared on the 4th, despite that the confession had been done on the 3rd, his lawyer, Mr. Koya, who was representing him at that stage, was not even told about A, the confession, or B, the diagnosis. Not told. Nobody even breathed a word about those two important things. Mr. Koya wrote a letter protesting about the constitutional right to know the charges and so on and so on. That was ignored. But what is worse is that on the 11th, when I got into the picture, so this is concealed from Mr. Koya from the 3rd up to the 4th when he's in the court. And then from the 4th to the 11th, which is another 7 days. Not a word about a confession or a diagnosis. I woke up in court in the morning on the 11th. And I'm told, literally, I think it's 10 or 15 minutes, I can't remember, but it's on the record, that, oh, we have this certificate from the DPP about the nature of the charge. There's now a new charge of terrorism. As I said, that trick I know because prosecutors do it all the time. A case like that, which unfortunately 2 weeks ago, the charges were withdrawn, the so-called abduction of the minister. Again, same thing had happened. I was in a bail application to not terrorism. Sorry, schedule is fixed. And this is done. But anyway, let's put that aside. But more importantly, my lady and my lords, in that 10-15 minutes, I'm then given the Fantonda diagnosis. Same dilemma. The lawyer who represents the accused person will always have this dilemma. What do? Do you then say, which is probably the intention, do you say, oh, well, I've now just gotten these documents, so let's drop everything, let's come next week. And then your client is going to be sitting in further detention. Or do you say, well, this is unfair, but let's go ahead. And that's what this court was referring to. Obviously, we chose the latter. We said, no, we'll go ahead with the bail application and we'll deal with these things, including the surprise documents. But the learned magistrate did not do that. He, we now know illegally, ordered that the person should be referred to the department. and the rest, as they say, is history. That has had a, what we call a domino effect. All those things have had a domino effect which has brought us here. We've been now, this is the fourth time we're in this court, in the High Court.
So essentially, Counsel, you're saying what happened in front of the acting magistrate had a direct impact upon the case.
To us being here too. And I'm saying that on two strands. The strength of this judgment, which links those mishaps, so to speak, to the to what they say is what was impacting on the applicant's rights entrenched in the Constitution. Mr. Mafe was entitled to apply for bail. So I'm saying by reading, and I don't want to bore you with the facts. So the deprivations of liberty on the 4th, the deprivations of liberty on the 11th, then lead us to his being confined to Falkenberg, remember. Then that leads us to coming here for the first time to do the review application. That is then set aside. By that time he has got COVID-19, so it's even difficult to consult with him. We then come back here on the 18th or 19th of January to do the review application. That is then referred back to, so we've been already twice in the High Court at that stage. It's referred back to the regional magistrate. And then of course the other 2 times is before this court, twice.
Didn't the review court correct that wrong, which was done in front of the acting magistrate?
No. It didn't, because you can't undo the fact. You can declare it to be illegal. It's like if I can be detained now for 12 months, and then the court finds 12 months later that it was wrong. I cannot undo what I've done. It really wouldn't. So I take the point that the court rightfully declared it. But the impact, remember we're talking about the impact, what I call the domino effect. That could not be undone. Because it's exactly what these learned judges are saying, that the bail application should have actually been held on the 11th. You can't undo that, because it's now January, and now it's June almost. So if the right thing had been done, and the bail application had been held on the 11th, and this law had been applied, that it doesn't matter. Let's assume at that stage everyone still thought that there was something wrong with it. That would not have deprived the bail application. In fact, these learned judges say that paragraph 17, Dr. Van Tondel's report in the circumstances would have been one of the factors to consider in the bid for bail. That has to be correct.
Advocate Mpofu, let me use the benefit of my being a rural boy.
Yeah.
All right. And in the rural villages, after the pastures, before you take your head of cattle back to the kraal, you via the fountain.
Yeah.
All right. Now, at the fountain, you before you drink, you wait for the muddied waters from the cattle hoofs to settle, so that you can see clearly what is there. Now, once that muddied waters have settled, all right, are you urging us what to see at the bottom? To be that either the inexperience or lack of skill of a police official knocking on off to a prosecutor and knocking on to the magistrate in bail application proceedings, that must be a factor as one of the exceptional circumstances. Yes. Is that what you're asking us to see?
That's exactly what I'm asking you to do, and let me explain why. Because, again, well, I'm glad to see a theologian grew up in the rural areas like me.
I'm a former head boy.
Yes, so am I. And the real issue here is that one has to, we must go to base one. We're dealing with a human being here, not different from me, from you, from anybody else. Presumed by the Constitution, no less, to be innocent like me. And the day we don't take into account the fact that that human being has been sitting for 5 months, 5 months in this winter in jail, and that part or a large part of that is because of the things that we are describing in justice to learn. In other words, if we can wish away all those issues, the inefficiencies of the police, the inefficiencies of the prosecutor, the inefficiencies of the learned magistrate, acting magistrate, if you can just subtract those things, that person would be free. Now, if that is not an issue that weighs before the court of law, then nothing ever will. Because that's why we're here. That's why you've stopped everything to sit here. There's no way that this court, as I'm saying, is now sitting for the 3rd or 4th time on this matter. Why? I'm sure if somebody had put an application in January, by now, an opposed application, by now it would not have been had. The reason that this one has been had 4 times is because we're dealing with a human being, and bail by its nature is urgent because it is with a human being. It's not a piece of bottle of water. And that's why we are here grappling with these issues. And I shudder to think that anything then that results in the indignity of incarceration of a human being without a trial, can be viewed as petty or unimportant. And this is what this court was pains to point out, that when it says Dr. Fandongo's report in the circumstances would have been one of the factors considered in his bid for bail, what the court is really saying is that bail application should have happened on the 11th, win or lose or whatever, but the mere fact that it didn't, and then led to all these other things, COVID-19 and what have you, and as I say, led us to be standing here today on the 30th of May. 5 months from that time is highly important. Let alone the fact that it also took him to Falkenberg wrongly. The question that the heritage asked correctly, that the impact of all those things. And I'm not taking the point that he got COVID-19 and where he got it and so on. I'm just saying, all those things would not even be factors had the right thing been done. That's why I said the system, and I'm grateful to the way the Van Pet justice to that, because it's different players in the system that have conspired, unwittingly so, I hope, to bring us here to where we are today. So I'm saying that with the greatest respect, and I'm saying that on the strength of what was said in S versus Lamin, I'm saying that on the strength of what was said in S versus C, that exceptional circumstances are not some like the 7 wonders of the world. They could be ordinary circumstances, the cumulative effect of which come into. So that's really the submission I'm making justice to. I'm not saying that fact viewed on its own in isolation, grant bail. No. I'm saying if you view that and you add to that the misdiagnosis, you add to that the hiding of information, you add to that not just the gross irregularity, the so-called confession, which is still a mystery, if you remember the discussion we had before. Because that confession was allegedly taken at 10 o'clock or something, on and then within a few hours, the Dr. Van Kolder visit happened. And that was on the same day of the day of arrest. Now, if you put all those things, and then you put the fact that Section 50 bracket 6D was common cause from the papers that it, again, hopefully by default, got breached in the sense that the 7-day postponement was ipso facto extended. One of the postponements, I think, went on for something like 2 weeks. I think that might be the time when he was in Falcon. All those issues, but crucially, the confession, the clear denial of rights, the fact that this person is not, by any stretch of the imagination, and Malena Friend again made this concession, that they went to his address and they even went to his other address in Mahake. So you are not dealing with anybody who doesn't have or rather who's untraceable or anything like that. And then what we're also told, Justice Pilar, that he says it himself, but one of the reasons why he is aggrieved by being inside is that it deprives him of his opportunity to make a living. Now, I said this earlier. Again, the day, that is usually, if I'm a wealthy businessman with 100,000 companies, and I say to a court, well, my being here is now holding up all my empire. That is regarded as an exceptional circumstance or something that in the interest of justice should weigh for my release.
Did I understand him incorrectly when I gained the impression that he said if he's released, he's not going to go and do what he used to do?
Okay. Thank you. We went through that in the earlier sitting. No, what he said, my lady, was that, and this was probably one of the most painful parts about what my learned friend, how he characterized that point. Because he said, he trivialized it by saying, no, when he says, yeah, he's going to go there and watch DSTV. And I said this once before, it's probably the most insensitive thing to say. Because what the person was really saying, my lady, was that because I'm now, yes, recognizable by everyone, quite frankly, it's going to be difficult for me to make a living because who's going to give me their plastic bags to carry into their car when I'm now this monster that is portrayed as cuckoo and all sorts of things. And this is what he said, my lady. The context in which that statement was written, page 93 of volume 1.
Is that page 93 of the...
Of volume 1, yes, that's page 76 of the typed translation. so this is what the Malayan friend asked him, sir, what is your, I'm sorry, against letter 11, another, the line 11. What is your plan with employment to be released on bail? No, I do not. I'm not doing anything about employment because I do not think I will ever get employment or anything now. But I think I will get donations from people who sympathizes with me and so on. Now, what is he saying? This is a cry from someone which, as I say, is being trivialized. This is a poor person saying, well, I'm now going to, even my job is going to be rendered ineffectual. But that does not mean that he's not going to, as I said, I think in the previous one, that might be, then that's what it means, that means he's going to wash people's cars in this area, those people who know him or whatever, rather than having to carry for strangers who might. But the point I'm making is that the gist of this is not somebody who just wants to sit excuse me, and watch DFTV. It is someone who's desperate, who's saying, well, now actually my job has been jeopardized. So that's the crux. So, and in any event, my lady, excuse me, the point I was making is a different one, which is that whether I earn 20 rand or 2 million rand a month, if my continued incarceration is going to jeopardize my economic wherewithal, then the court should blindly, and I say that boldly, should apply the same standards to the poor as to the rich. And again, I think we did agree on that last time. If you just allow me.
Yes.
Yes. We've already said that he also makes the point about his recognizability. And again, that's because, of course, as we can see now, this matter is not your ordinary matter in the sense that of what's happening in all the other courts around the country. And therefore, it's a valid point that he makes that even if I was a flight risk, it would not be as easy for me to just disappear like any other accused into society. And as I say, it doesn't matter whether you think that well, firstly, nobody can disagree with that because we all know that his face has been blamed not only in South Africa but internationally. But the question you may say is that on its own, and I use those words advisedly, is that on its own an exceptional circumstance? Maybe not on its own, but viewed cumulatively with all the circumstances that we're talking about. And you'll remember, my lady, I'm sure this court in SABC has said that there's no such thing as exceptional circumstances in the extreme sense. All it says is that it's the normal circumstances, but there's a heightened test. And that goes back to base one of what is this exceptional circumstances thing. And the courts have been at pains to say that for the reason that I started with. Obviously, the law must differentiate between offenses. It does that all the time. And therefore, all that was done really by Section 6011A, which has now been elevated into something else, is to say that you have a higher burden because you are charged with a serious offense. But it is not a higher burden to do anything different than what the person with a traffic offense has, which is to show that in the interest of justice they should be released. They simply have a heightened heading, so to speak. That's all. It's very, unfortunately, complicated by lawyers, as everything else. And that's the basis upon which it survived unconstitutionality in elsewhere. If you allow me, I'll just read out what Van der Berg says at 104. Some misconceptions regarding the proof of exceptional circumstances. Please forgive me, I'll try and jump the unimportant parts. So, although it will be clear from the discussion that the Constitutional Court has given approval to the judgment in C to the effect that the cumulative effect of ordinary circumstances may suffice to establish exceptional circumstances. That's the point I just made now. The crucial point. It's too many unhelpful attempts have been made to give the precise meaning to the term exceptional circumstances. Sadly, there appear to be few prosecutors who are able to resist asking the accused, why do you say you should be given bail? And what is exceptional about your circumstances? Whereas in law, no catastrophic event in the accused's life is required for exceptional circumstances to be found. Even more sadly, says the author, many a practitioner unnecessarily continues to attempt valiantly but vainly to elevate mundane domestic circumstances to an exceptional level instead of studying the case law. Saddest of all is the fact that numerous judicial officers in both lower and superior courts appear to be oblivious of the fact that, quote, ordinary circumstances may meet the challenge of Section 6011A. Another aspect deserving of comment is the tendency of prosecutors, especially in Schedule 6 matters, to overemphasize the element of seriousness by attempting to prove the accused guilty during the bail application and being permitted to do so by magistrates, who often go on to all but find the accused and guilty and to refuse bail without even dealing with the risk factors and how they could be addressed. Let me pause there. The risk factors and how they could be addressed. And we said this. And that's why we all know, I think I made this example before. That's why you say, okay, I'm giving you bail because you are a human being, but you must surrender your passport or whatever, or all of this. So it doesn't mean if I'm a foreigner, for example, I must not be given bail. It simply means that I must be given bail, but subject to stricter conditions than a local person. So the mindset should be to release the person, and then you say, okay, if you release them, how do you circumvent this and so on and so on. And we all know people have been asked, some people to report 3 times a day, which I think is pushing it too far. But those things happen, or once a week or whatever, simply because it must be calibrated to the particular circumstance. And then they say, instead of doing that, alarmingly, this attitude is all too frequently endorsed by certain judges. This unfortunate state of affairs has led to practitioners increasingly decided to address the merits of the charge during the bail application, a tactic which, although perfectly legitimate and sometimes successful, unnecessarily converts the bail application into a protracted adversarial battle, which really reaps the rewards. So, what are they saying here? Two important things. One is that, so what with a naked eye might look like ordinary circumstances put together amount to exceptional circumstances. But more importantly, they also decry what was done here, which fortunately the appellant resisted, which was to try and enter the merits. And in that respect, I must commend the learned magistrate, because although there were gray areas, she did say, and I remember specifically her stopping my learned friend, no, we can't go into that because the accused person has said that he doesn't want to talk about the merits for the reasons that are explained here. But it is that mishmash of trying to show that it's guilty and conflating that with the bail application issues, or overly inflating the seriousness, as if seriousness on its own is a factor, or rather, well, it's a factor, it is a showstopper, or a total condition for denial of bail. We know that the law, base 1 says that, and this question has been asked, is there any offense for which bail is not applicable? And the big answer, a simple answer is no. It doesn't matter, I could kill 1 million people or whatever, but I am still entitled to bail. It's just that I have to climb a higher. And those are the nuances that get lost in this, because it's natural. We all get, if you've got this person, they say, look, this person is a serial rapist or whatever it is. Yeah. The natural instinct is to say, well, why should they be out there? But unfortunately, the law says they should. The law says that person is as innocent as any other person. Because we can't have what Mohammed calls anticipatory punishment of that person. And we must resist it. It's a human instinct, but we must overcome it and quickly go back to the law. You say, this is a person who is innocent. This is a person who has a right against detention. This is a person who has a right of the presumption of innocence. This is a person who has a right not to be, or rather, to be released and coming to the facts of this case. This is a person against whom improperly obtained evidence may not be used. Ironically, my lady and my lords, the very issue, if there's any relevance of this confession issue, actually it's one that should operate in favor of the appellant. Because, remember, we all know that one of the legitimate factors to be considered is the possibility of an acquittal, for lack of a better word. Now, if indeed we have this piece of paper called a confession, and it's not what the paper is written on, as we all know now, then that should have an impact on the extrapolation that we should have of what might or might not happen at the trial. And I take the point that we know we don't have the trial within a trial now. But on what conceivable basis, really, could a so-called confession that fails all the 3 tests I mentioned earlier ever survive any trial? It won't.
Why are you, sorry to interject, counsel, why are you shying away from the video footage?
Well, for 2 reasons. One is it was rejected correctly, and secondly, it goes to what I've already said. I won't repeat it. Even if that's what I was saying. And I think I made this example in Even if I go on the day of the soccer final between Kaizer Chiefs and the London Pirates, in front of the whole country watching, and I go and put 100 spectators there, and you can see that it's me on Saturday. On Monday, when I come here before you, Mary, difficult as it might be, because you could have been watching that game as well, you have to disabuse yourself of that notion and apply the law. That's all. Just say, okay, this person is presumed innocent. I know it revulses every bit of juice in me, but this person must be presumed by the law, by the Constitution, by the founders of this society. When they did that, and I go back to this point, when they do that, the biggest problem we have is that we think this person, not this one. But when they were doing that, they were not doing it for that person, that vile person who shoots people in the stadium. They were doing it for you and I and all of us in society to have standards by which we judge other people. And I think I mentioned this, that one of my favorite sayings in law is the one that says, it is better to acquit 9 guilty persons than to convict 1 innocent person. That again, something that makes you not feel good. But that's the reality, that's the law. The law is that we have chosen, rightly or wrongly, a system, even under apartheid, that system operated, that it is better. That's why you have this heightened reasonable doubt standard and so on, so that the individual can be protected. Not that particular individual, the individual in the abstract sense of the word. So those are not easy issues, my lady. So the exclusion of the video evidence was again because of this surprise element. Because again, this was something that was sprung on us. I mean, that one was even worse. Because I think it was, if I remember well, it was even in the afternoon when we all thought we were going home. Boom! The video was sprung on us. So it was correctly excluded.
Was it not excluded because of convenience, that it should not be played?
No, it was not. There was full, remember my lady, and I'll get to the record, there was full argument. Because the idea was, again, I mean, that's why I say even I had to draw the line. Because, having made that compromise on the Tehran statement that it can be brought later, here we just said no. We have to argue it now, literally. If it means we're going to be here for another hour or so, so be it. And you remember from the record, there was legal argument. And the learned magistrate found in our favor that it should not be paid. Now, it doesn't really matter why it was excluded in the end. The point I'm simply making is that it was excluded. So therefore, it's let me put it this way. It's impossible. I can put it as strong as that. It's impossible that the learned magistrate, at least, took that into account, because she could not have spoken with both sides of her mouth. She couldn't have said, I'm excluding it, but when I get to my chambers, I'm going to look at it. We must just accept that she didn't do that. I think in fairness to the learning magistrate.
Yes, but then on that video footage, if the video footage was excluded, there were photographs which were depicted, which came from the very same video footage. What is your comment on that? Because the magistrate also relied on the still photographs, not which were apparently produced from the video footage, which video footage was excluded from the record.
Thank you. Yes, no, thank you, my lord. I'll address that. I was just addressing the specific question from the leadership.
Yes, thank you.
No, I've already said what I've said about the so-called affidavit as a whole. So I want to repeat. The second issue about that is that surely, again, just from a sense of fairness, so surely you can't say we're excluding the video footage, but we're going to admit its babies. So to speak.
Counsel, let's be fair to the magistrate, the regional magistrate. Have you considered her reasons for judgment? Because she wrote a judgment. It's actually a very short written judgment, 2 pages. On her reasons. Yes. But she gives reasons, and my understanding of those reasons differs from the propositions that you're making as to her stance on the video footage as well as the photos.
Justice Tulala, then maybe at least.
Look, it's a very short thing. Let me read the 2 paragraphs that I'm referring to. All right. And is the second sentence on page 194 and page 195 of the transcript.
195.
I'm reading the judgment. The judgment appears on 101 in volume 2.
Yes, I've got it. 195 of the type.
101 of the marked pages,
yes.
Not the typed pages. The last 2 pages of volume 2.
Got it.
Yes, and I'll just read what she says because I want us to be fair to her. And I was reading the second sentence. On page 194, paragraph 10 and page 195 of the transcript, I indicate that in considering some of the submissions, the overriding factor that was kept in mind is that the court was tasked to adjudicate on the application brought by Mr. Mafe to be released on bail. And while one of the factors which may aid the court in considering such an application would be the strength of the evidence implicating the applicant in the alleged offences, it must be remembered that the court hearing a bail application is not hearing the trial, and as such, not encumbered with adjudicating and considering the extent of the evidence against the applicant during the bail application. And the last part that I want to read on, it says, it was also taken into account that in relation to the evidence that the state wishes to adduce at the trial in attempting to prove the guilt of the applicant, statements were put to the applicant during cross-examination, and these included reference to the video footage concerned and what was depicted on it. After viewing the footage and having been given an opportunity to address, the defense did not gainsay the statements put to Mr. Mafe in general terms, particularly regarding what was put to him by Advocate Menigo in relation to the contents of the said footage. So I do not understand these reasons to be in line with the propositions that you're making in relation to the posture that the regional magistrate took in relation to the video footage and the photos emanating from it.
Thank you. Justice Tulala, you know, I think I've been at pains, at least anyone who's listening here will accept that I've been at pains to be fair to the learned magistrate.
Yes.
Even whenever there's doubt, to make sure that we don't exaggerate the problem.
Yes.
So please, let's just at least get that one out of the way. Secondly, I've just said to her ladyship now that it does not matter what the reasons for the magistrate were in the exchange that we just had now.
Yes.
So I come with the same person who then said that nobody gave this reason. I've said it doesn't matter whether the reason was because the sky is blue or whatever. It does not matter. Right?
I see. Perhaps I misunderstood you because I understood you to be making a proposition that the magistrate in her approach to the judgment excluded both the video footage and the photographs.
No, I never said that.
I see.
I can't say that. I'll say on the video footage, I addressed the ladyship.
Yes.
Justice Lekulen is now asking a different issue about the photos, and that's what I was addressing.
I see.
But since we are back at the video footage, so that I'm not misunderstood
yes.
at all, I am saying whatever the reason was and that's what I just said to the leadership. Whatever the reason was, whether as I said because the sky is blue or whatever, the fact of the matter is that the video was excluded. So at least we are happy, we're done with that.
I see.
Yes. Now, I was saying, therefore, and by the way, these reasons, the ones that you are reading from,
Yes.
they're not, it's not the judgment as such. It was because, as you know, when the bail is being appealed,
Yes.
the magistrate has to justify whatever was done.
Yeah.
So this came much later than, sorry, I don't know if this thing is later.
Yeah, but I understood the process to say they came after the record in the magistrate explaining her ruling at that point.
No, I didn't. She,
Yes.
remember, at that point in court, all she said was it's excluded.
Yes.
Basically, for obvious reasons, because we were in court.
Yes.
I don't think she would have had time to. So I'm not. The point I'm making is that I'm not faulting her reasons. That's not what I'm about. I'm simply saying that the video footage was excluded for better or for worse or for whatever. It was excluded.
I see.
Yeah. Now, the coming back to the question that was posed by Justice Zandile, I'm now saying that I was making the metaphor that the photos are the children of the video. But the more serious point I was making is the following: that the so-called still photos must be read together with what I said earlier about the criticism of the affidavit. Remember, they come as attachment to that affidavit which was sprung on us on the PM or whatever. So the accused person had not had, literally not even an inkling, neither did I, of all these things. So it was impossible to even deal with that. But be that as it may, the point of the matter, it goes back to the basics. At what point can the still photos be now, are we now going to reduce the court to an expert? Now, remember, these are things that are going to be dealt with at the trial. And I can assure you right now, that they'll probably be dealt with for many days or weeks, where there'll have to be facial recognition experts and all sorts of people like that who will go into all this. The court knows what I'm talking about. So all those issues cannot, with the greatest respect, be determined in a bail application decisively against a human being. They can't. That really would be, I mean, I don't know of a system that could be. But okay, every time I'm saying, I assume I'm wrong even in that. Then it comes to the point about the so-called, it comes to my example of the Ellis-Park shooting. So in other words, even if there was no issue of recognition experts and all sorts of things, the presumptions and all the things that I've said earlier, which operate in my favor, should convince any court that this, I mean, really, I can't be denied bail simply because there's some photo of somebody who at the stage we don't know who that person is. So I must sit for 2 years until the matter comes to the High Court, because we now know it's common cause that the matter will be referred to the High Court. And it goes back to what I was saying to your leadership about that you can't undo these things. Let's say later it's found that let me make an example of Mr. Court. it's found that this picture was somebody else. In case they show their listings. Let's say that, which is how our posture should be, that it is something that is not proven, is not proven. So this court, for example, would not be entitled to say, but Mr. Hoff, let's go to photo number 6. Do you see the earring there? And we can't do that.
But an assertion was put to him by the state. And
Yes,
said, that's
it
you.
was not put to him. The assertion was contained in a dubious affidavit which was presented on the PM, right? And that was the basis of the so-called assertion that was put to him. And his refusal to deal with the assertion, my lady, is based on what the learned magistrate herself says is entitled to do, which is to refuse to answer anything to do with the merits. That's what she said. That much, and that's why I was saying I'm not being unfair to the learned magistrate, because I've given her credit for that, rightfully so. She said, that's the actual reference. I'll find the reference, but it's common cause that she said that in stopping my learned friend from probing some of those questions, but the person has said he is entitled, as we all know, not to deal with those matters. Because, again, it's another conceptual borderline issue that the court always has to deal with. It's not an easy one as well. And that goes into the rights against self-incrimination, which is also another constitutional right which must not be forgotten. But the law says that if faced with a possibility of self-incrimination, you have a right, it's also linked to the right to silence. Right? Now, at what point are we going to punish a person for exercising their constitutional rights, for saying, and affirmed by the magistrate, for saying, no, you don't have to answer that now. And in fact, I remember where the appellant, when he was on the stand, he kept on saying, his refrain was, well, that is for the High Court. That matter will be dealt with in the High Court. That matter, so that was his shorthand for saying that is a condition for the child. We are not entitled, with the greatest respect, to then punishing for that. But even if we were, again, even if we were, seriousness or not seriousness as such, the strength of the state's case is not something that should be used to deny bail. The strength of the state's case, yes, of course, it's a factor. But none of these things, must be elevated to, there's a picture, and that ear looks like it's you, therefore, no bail. It doesn't work like that. Because we all know that a court of law, I can't remember the person's, some English judge, who said the law books are strewn with examples of what looks so obvious, which turns out not to be. It was a statement made, it's Justice something, I forget the name, but in the English court. And that was a statement made in justifying the rule of audi alteram pater. She said, when the trial happens, when everyone now has a right to refute, to bring this expert and that expert, all sorts of things that look so obvious, like my example of the statement, are not as obvious as they may be. And therefore, again, benefit for all that must go to the individual. It can't go to the state. Because the state, after all, has got the wherewithal to bring the best photographic expert in the world, as opposed to an individual who might say, look, all I can tell you is that I'm not there, it's not me. I can't bring all sorts of sophisticated machinery to prove it. So even if the photos, as I say, were literally real life footage of something, that may go into the strength of the case, but it's not a very decisive fact. So the problem is exactly that, to elevate. Now, in other words, you have to overcome mentally now all these problems. First, you must overcome the fact that the video was excluded. Then you must overcome the fact that the affidavit was presented late, wrongly. Then you must overcome the fact that the photographs come from the video. Then you must overcome the fact that the photographs actually might be meaningless because we have not yet had any actual evidence. How do you overcome all that? For what? Firstly, why do you want to overcome all that? Because it's almost like we must find a reason to keep this person in jail. No, it's the exact opposite. We must find a reason not to keep the person in jail. And if there is a tangible reason, yes. But is that a tangible reason? Some photo, some description in black and white? No, clearly not. And anyway, it goes back to what I was saying earlier as to the conceptualization of this thing of the onus versus the constitutional rights. Because this onus thing is used as a red flag, to as if it could overcome the constitutional right. Oh no, Section 6, then now the onus is the new, you are doomed, you're going to stay there forever. Let's forget about all your other constitutional rights. That's the first fallacy. The second one is this one about exceptional circumstances mean that the sign must come from the west and not from the east. No, it's not anything like that. It's a cumulative effect of what would ordinarily be normal circumstances in any bail application, such as the propensity to abscond, the fixed address. It doesn't mean we just throw away the entire Section 60 just because we are now in Section 6011. We still go through the same things. Is there a propensity to invade? Is there a propensity to interfere with witnesses and so on and so on? The big five issues that are in Section 1624. And here, again, in fairness to the magistrate, here she did not make any findings about all those issues. She only confined it to this one issue that where she wrongly found that he had said he's going to do it. Kind of, I'm paraphrasing. So, in fairness to her, she never said all these other things were determined. But I'm showing you that on the one issue where she did it, which was, I think, Section 64A, she was wrong. So if she was right in this other four, and she only relied on this one, but she was wrong on this one, then of course the judgment must be reversed. That's the bottom line. Can I just check?
Yes.
Just to see.
And without limiting you, I think we've given you ample time, Counsel. We're also involved in other matters today, but but I understand the complexity of the issues.
It is, but also the questions, more the complexity of the questions.
And yes,
which are welcome, but they have to be.
No, that's correct. If we can round up, yes, please. Round up.
Yes, okay. Now, I've already said that the issue about being ambushed at different levels, I think I've made that point, including the video, the so-called diagnosis, yes. I just want to refer, I know I might deal with this in reply, depending on what my learned friend has to say, but my memory says that me and him were also in agreement about the test postulated in Potten, in SSS Potten. But so that I just wanted to highlight something, Potten in paragraph 17, I think. Yes. Paragraph 17 of SSS Potten, where it was also in this court. Judge Bin's word. He said, without in any way detracting from the court's duty to respect and give effect to the clear legislative policy inherent in the provisions of Section 1611A of the CPA, that save in exceptional circumstances, it is in the public interest that persons charged with the class of particular serious offences listed in Schedule 6 of the CPA should forfeit their personal freedom pending the determination of their guilt or innocence. That is, as in S. claiming in paragraph 15 or whatever. It is still necessary to be mindful that a bail appeal, this was an appeal like this one, including one affected by the provisions of Section 1611A, goes to the question of deprivation of personal liberty, the point I've made repeatedly. In my view, that consideration is a further factor on its own, confirming, on its own, is a further factor confirming that Section 65(4) of the CPA should be construed in a manner which does not unduly restrict the ambit of an appeal court's competence to decide that the lower court's decision to refuse the bail was wrong. See Section 39(2) of the Constitution of 1081, 1993. What this court was saying in different words is the point I made earlier, that any statute must be interpreted in terms of Section 39(2) of the Constitution, as we all know. In other words, any statute such as Section 1611A must be interpreted in the context of our human dignity regime, the fact that we live in a free, supposedly free society that values equality of rich and poor, black and white, and the human dignity that inheres in all of us, is just because we are human.
Thank you.
Yes. Therefore, and I ask for submission, given all the, whether it's the concessions from alleged confessions from the appellant, the full combination thereof, particularly in respecting the reasons given by the learned magistrate, should leave no doubt that decision was on.
Thank you very much, Mr. Mpofu. Thank you. Yes, Advocate Menigo.
My Lord and my Lady, I'd like to start with Section 65 once again. specifically looking at what the court needs to consider in this particular case. Now, specifically, the court needs to decide whether the lower court was wrong in its decision. That's the critical thing that's in all the cases that I quote. I refer the court to its argument with respect to page 2 of the argument which deals with the application of 1665. Summary of paragraph 2.2 and 2.3 is mainly that the ordinary considerations when it comes to the application of the case when it comes to the agreement. Now, specifically related to the matter of Portland. Portland was applied by the Portland State versus London. However, I'd like to draw the court's attention to the paragraphs 12 and 13 on the matter of State versus London. Starts by considering at paragraph 11 the Portland judgment. It says the following at paragraph 12. The Board AJ then concluded that section 65.4 of the CPA should be construed in a manner that does not unduly restrict the ambit of the appeals court's competence to decide the lower court's decision to refuse bail was wrong. At paragraph 13, and this is the judgment of Stratham, the full court of the Gauteng division. I am of the view that this court can only conclude that a court was wrong if it considers all the relevant aspects for and against the granting of bail to the applicant. If this court then is of the view that the court of quo, in light of all these circumstances, should have granted bail to the appellant, the only conclusion would then be that the court of quo's decision was wrong. That's where the report ended, the quotation from Zandile, but he goes on further. Paragraph 40. Thus, to be successful in this appeal, the appellant will have to show that the court of quo overemphasized aspects which militate against the granting of bail, whilst aspects in favor of the appellant were not given sufficient weight. It speaks to itself for itself if this court cannot conclude that the court of quo wrongly weighed up points for and against the granting of bail. This court would not be at liberty to consider the issue of bail afresh. The court's of quo's decision will have to stand. So this is what we are dealing with in this matter. Section 60 eliminated. Did the court correctly find that there were no exceptional circumstances in the interest of justice permitting the release on bail? Now, what the appellant has correctly argued was that the case in Ashton, it's very much like the case in State versus Lamini. The difference between Ashton and Lamini is that Lamini unpacks what needs to be done practically. It's not only about constitutionality of sections, the so-called bail section. It's also about some sort of guidance and direction to courts as to how to approach bail proceedings. And in this case, Schedule 6 bail application. It gives us a framework on which to apply the test. It says, weighing up the liberty interests of the accused with the interests of society and making a value judgment as to whether it is in the interest of justice for this accused to be thrown bail. So what did the magistrate do in this instance? A list of circumstances were argued, submitted, argued, presented during evidence, and that list was dealt with by the magistrate in her ruling. She dealt with every exceptional circumstance, proposed exceptional circumstance, and found at the end that there were no exceptional circumstances amongst those listed by the defense that warranted a finding that it was in the interest of justice from the very least. But further than that, this court also has to look at the weighing exercise. Once the exceptional circumstances are not there and are dispensed with, there's still the weighing exercise that needs to take place. The interest of society versus the liberty interest of the accused. And it's not a mystery where those are. They are found in section 64 of the Criminal Procedure Act and Section 69 of the Criminal Procedure Act. The liberty interest of the accused in Section 69, Section 64 that it deals with the interest of society. Now, where the state has, in its set of argument, has dealt with all the exceptional circumstances that were raised and the arguments that the state has presented under from page from page I would say page 14 onwards of the state. Every exceptional circumstances raised in the head of argument of the appellant are dealt with and dispensed with. The magistrate has done the same exercise. She doesn't dealt with every single argument, whether meritorious, whether meritorious or not meritorious. She has indicated these were the things that were given to me as exceptional circumstances, and I find that they are not exceptional circumstances. What has been argued today are that there are perhaps two other circumstances that perhaps are not placed in front of us. A consideration of the confession, which wasn't obviously an exceptional circumstance in respect to what she needed to be considered. It's been posed to this court as an exceptional circumstances after the. The other is the so-called process that took place in the magistrate's court from the time of the accused arrest to the time of his. Can that be construed as exceptional circumstances, warranting a finding that the accused should be permitted to release in the use of justice. Now, in order to look at the latter part of the argument first, this process. One is to consider the factual background. Now, we've had a mismatch of what the factual background to that ultimate finding with respect to Section 78, the review application. But in paragraph 4 of my heads of argument, starting at page 9, based on nothing but the charge sheet, what is written in the charge sheet, a factual background can be established as to what actually happened in the magistrate's court, and whether there is such an egregious infringement on the rights of the accused needs to be considered in light of this factual background. So on the 2nd of January 2022, the appellant was arrested and appeared on the 4th of January in the Cape Town Magistrates Court. According to the proceedings of the 4th of January, captured under paragraph 4.3 on page 9 of my head, the state and the accused legal representative agreed to the court granting the applications of media houses, so the media application was granted regarding the public interest. Then the state advised that Mr. Godla was appearing for the accused, and the state represented by Advocate Gelderblom indicated that the accused bail release was being opposed. The state prosecutor, according to that letter, then advised that there was a dispute between the parties around the schedule of the case. The state listed the charges and advised the court that the residential address of the accused had been confirmed. Mr. Godla then submitted to the court that the offence was one of arson and was a Schedule 1 offence, and submitted that the accused should be released as he was not a flight risk, had no previous convictions, no pending cases, and no outstanding warrants. The court, having heard counsel, postponed the matter for bail information on the 11th of January. Not bail application. If you read the report, it says bail information, which should only have been done in terms of Section 56.
I'm sorry, counsel. Are you submitting that is a different thing?
Bail information, my lord, paragraph 4.4 explains why that is a different thing.
Yes.
Page 10 of my list. Section 56D of the Criminal Procedure Act allows a lower court to postpone bail proceedings at 7 days at a time if there is insufficient information before.
Yes, but what is being postponed is the bail application.
The bail application is being postponed, but it's not being postponed for bail application. It's being postponed to garner sufficient information in order for the court to decide whether, from that point onwards, the matter is then postponed for the bail application. That is the ordinary ordinary approach. If there's no opposition, the bail information may come back.
So I want to understand you precisely on this point, because it worries me. Are you suggesting that the legislature's clear intention that bail should be had as expeditiously as possible and very clearly on the first day of appearance, all right? But if the state is not in a position to do so, that the presiding officer, if he is of the view that there is insufficient evidence, may postpone that bail application for a period not more than 7 days. Are you submitting that the intention there is not that at least within 7 days from the date of first appearance, the bail application must be had? Are you saying that the state has got a liberty to kick the ball further?
No.
Or whatever the team is?
The state has got the liberty to apply. The court has the liberty to deny any further postponement. And that happens on a day-to-day basis.
Yes.
But at that point in time, it was for bail information. To obtain the sufficient information, the court at that stage felt that it had insufficient information in front of it in order to determine whether to proceed with the bail application. It was one thing. There was dispute on the schedule.
One of those days when many court matters are currently underway. We're going to dip out of that to go to this one live. The matter trial of former Orlando Pirates and Bafana goalkeeper Senzo Meiwa starting at the High Court in Pretoria. Let's take you there live.
Have filed certain submissions that, my lord, they want to amplify at this stage. There were also certain issues, my lord, that we came to see the court in chambers about, and I will then at this stage just stand down for perhaps those issues to be ventilated, my lord.
I see.
Where you don't have sufficient information, you run this bail application in the dark. Later on, it appears that the accused had 110 cases, perhaps. Sorry to use the 100%, had perhaps a pending case of rape, and he gets released on bail. And then he goes out and he rapes the complaint, and then we go to the Supreme Court of Appeal, and we go to the Constitutional Court, and the state is found wanting, and damages are awarded. That is the reason for Section 56. So that the court has sufficient information to make the correct decision, to make the correct value judgment.
I see.
Part of that information, the schedule, that is the most basic, because if you don't know whether it's a Schedule 1, Schedule 5, or Schedule 6, you won't know how to run the proceeding.
I see.
So Schedule 6 will mean that Section 11A comes into operation. Section 11A, then you have to determine whether exceptional circumstances need to be presented.
I see.
So that is the purpose of that particular section. But there's more. Under Section 56D, besides the insufficient information, there's the certificate from the Attorney General or the Director of Public Prosecution. That's one of the aspects. And then there's even the broader aspect that the court has, if it is in the interest of justice to do so. So Section 56D says 7 days at a time, but it also gives the court certain grounds on which to grant that particular postponement. And in this instance, the court said, I have insufficient information. What the court could have, or the prosecutor could also have addressed the court on is the fact that it is this dispute on the schedule, allow us to go to our Director of Public Prosecution to prima facie issue a certificate which prima facie proves what the schedule for this offence is going to be. And what happens on the 11th of January? A certificate of this nature is produced. Indicate that this accused is being charged with terrorism, and Section 6011A now starts application. You need to then hold the Schedule 6 application. So that was basically.
But is this very understanding of the state not at the heart of the problem of what happened on the 11th?
Well, the problem
if the state's view is that the postponement on a first appearance of an accused person is not meant for the hearing of the bail application, all right? Is it not at the heart of the problems of what happened on the 7th, on the 11th?
No, the heart of the problem, my lord, was not the issue of the bail application. think the heart of the problem and this section on the 11th was the issue of the second document, which was the document related.
The
to
High
Section
Court has
78.
already found that on the 11th, what ought to have happened was a bail application.
My Lord,
That's what the review judgment says.
yes, my Lord, but understand the nuance. Despite Section 78,
Yes,
right? Remember, we have the benefit of hindsight.
yes,
Despite Section 78, the court was saying that the accused could still bring a bail application. I think in that
yes.
instance, the
And we are
magistrate-
talking about, remember, we are dealing with your understanding of the legislative provision of a postponement of a matter where bail application is not being had on the first day.
Yes, sir.
You see?
Yes.
And we know that the bail application of Mr. Mafe was not had on the first day.
That's correct.
It was postponed. All right?
For bail information.
What was postponed was a bail application. You say it was for bail information. And I'm saying, if that is the understanding, is that not at the heart of the problem?
No, no. I think then my Lord has misunderstood. My Lord has misunderstood.
Yes.
Bail proceedings were postponed in order to garner in further bail information. That, I think there's a distinction between what the court is privy to. It's not, that is not my answer.
So Mr. Mafe was not entitled to be heard in his application on the 11th. That's
No.
what the state is saying.
No, that's not what I was saying, my Lord.
Yes.
That's what the magistrate determined.
That's what happened.
That's what the magistrate determined,
Yes.
which was found to be irregular.
Yes.
You may have been able to hold a bail application. We may have been in a position to. We don't know that. We never know that.
Yeah.
What we know is that the High Court says that despite that Section 78 finding, he should have been he should have been allowed to bring a bail application.
Yes.
And
And I hear you arguing differently.
I'm not arguing differently. He could have brought that bail application. He could have insisted that the bail application be brought. Those affidavits could have been placed in front of the magistrate on that day, and the state could have been, if they were not ready to answer, could have asked the court. But we speculated.
I see. You're welcome to proceed.
We speculated. So, from that point onwards, my Lord, what happens is the matter then, the Section 78 process happens, and the matter is, the accused is brought before court on the 13th of January, and on that day he's sent to court. But that's not all that happens. The bail application for the accused is postponed till the 14th of January. That is indicated there. On the 14th of January, in the lowlands, on the 14th of January, the appellants go to the High Court. Now, what is the problem with that process? The problem with that process is that the judge president, first of all, let's start with the judge president, let's get back to the statute. The judge president has determined in this division that bail applications are not to be brought in line. And there are very, very good reasons for that. There's practice note 34. You don't bring bail applications at the High Court in the Western Division, but there are legal reasons for that. It's peremptory in the Criminal Procedure Act that bail applications are heard by the magistrate's court unless the regional court is designated. Despite having armed with that knowledge of the Criminal Procedure Act, the practice directive of the judge president, the appellants go to the High Court with a bail application. That's the factual matrix beginning. They go to the court, and what happens at the judge president? The judge president says, I have a practice directive. You don't bring bail applications in the High Court. You may amend your notice, however, to look at the referral of this magistrate, and I believe there's a problem with that referral.
Was it not a dual application, an application to review the decision of the magistrate as well as the bail application?
No. That is where the magistrate is actually 100% correct. The bail application, and my Lord, if you were at the review application, the Honourable Judge President on that bench said, we're not dealing with the issue of bail, that will be dealt with by the regional court. We are dealing with the issue of the review. So, why that is important is because we've been criticized constantly that there are no opposing affidavits in the review with regards to bail. But that matter was not, the court was not seized with a bail application. The court was not seized with the bail application, so why should there be affidavits from the state with regards to the bail? The bail opposition affidavit was filed where it was supposed to be filed, and that was at the magistrate's court when the bail application was ready. So all those arguments, Plascon, Evans, whatever they want to bring in, or their parent wants to bring in, it just has no merit. So what the court then decides is that the finding of the magistrate was irregular, and he sends the matter back to the magistrate's court, the regional court. We were to hear the hearing. The hearing was for the 22nd of January, however it was postponed due to the COVID situation, and the hearing was then, the bail hearing was then. Now, my Lord, so just with respect to that as being an exceptional circumstances, this is a matter of state versus Ali that I've quoted in my notes. Any delays that are attributable to the state cannot be viewed as exceptional circumstances unless they can be shown to be male fide. My Lord, if one goes through that process and the mishaps Mr. Hawkins referred, there are no male fides, there's no male fides on the part of anyone in that process. On the part of the prosecutor, the state, the magistrate, the Honourable Judge President, there are delays caused, as Mr. Hawkins said, introduced to mishaps, but those instances when there was decisions that were judicially made during that whole process, whether they were correctly made or not, was reviewed by the High Court and found not to be so. But they cannot point to any sort of male fides. If there was male fides on behalf of the state, then perhaps this argument could have some sort of.
What about the assertions which were just made by the counsel on behalf of the appellant, that the state was involved in ambush litigation?
Ambush, how much? If one looks at the bail application, let's divorce ourselves for a moment from Section 6011A certificate. Section 6014 says that the appellant or the bail applicant does not have any right to any access to the case. That, however, is not unfair. The state has the proviso that the prosecutor may decide to disclose certain aspects of the case to the accused. If the prosecutor unreasonably withholds information, the magistrate also has, in terms of Section 63, the power to say to the prosecutor. So and so. But, it's a claim right. It's a right that needs to be claimed. Now, the appellant knows that the state is in possession of the video. I have, in his own affidavit, you can see that he's aware of the video. Number two, he's aware that he's accused has made a statement because he made some allusion to being taken by a white man. So he's aware of these two things. Now, for 27 days, right, the appellant doesn't do anything. He doesn't apply for the access to the video footage from the state. He doesn't, in terms of Section 335 of the Criminal Procedure Act, you are entitled to a statement made by your client. Despite, notwithstanding Section 6014, he does nothing. For 27 days, the appellant lies prostrate and doesn't request any information or particularity on the charge from the state.
But would that be fair criticism, counsel, having regard to the fact that it doesn't appear to me that the state, even at the first appearance, addressed the court on the substantial facts upon which the state's case is based? You see, if there was that form of an address, all right, to say to the magistrate, Your Worship, we are standing before you, this is Mr. Mafe. The allegations against him are 1, 2, 3. And the state would rely on number 1, number 2, number 3, number 4. All right? And there was that summary of substantial facts. Then it would appear to me that your criticism would be valid because Mr. Mafe would be knowing, all right, what the state has in its docket. But to suggest to us that he should have asked for information when on the record there's no indication that he was in fact apprised that the state is in possession of this information. Remember, as a classic example, what we know, which is uncontested, is that the day after his arrest, he was taken to a medical doctor, right? On the face of it, that report was in the docket, unless the state, the prosecutors wants to suggest that the police are withheld substantive information from them. On the face of it, that report from the medical doctor was in the docket, or at least ought to have been in the docket, when Mr. Mafe made his first appearance on the 4th, which suggests then that the prosecutors were aware of that. But we are told, up until the 11th, Mr. Mafe did not know. Now, if that be the case, how is it fair for you to say he should have asked for information that he did not know about its existence?
My Lord, when I'm referring to requesting information,
yes,
it's for the preparation for the bail application.
Yes.
What normally happens is the defense will ask the state for information.
Yes.
Because the state is not in...
I am at the first appearance, Mr. Mafe is indicating his intention to apply for bail on his first appearance. And I'm saying the state is in possession of a medical report in its docket. All right? And I'm saying the state did not rise and say, we are relying on the substantial facts, not lead evidence on it, but simply to address the court to say, amongst the information that we are having, it's a medical report against Mr. Mafe. So if you stand up now today and say you ought to have requested it, how fair is that if there is no indication on the records that Mr. Mafe would have been aware because the state indicated in respect of which information it has?
My Lord, at the first appearance, what ordinarily happens is the state charges the accused on the available facts.
Yes.
Right. So what are the available facts? Or whatever contained, it should ever contain the document. However, it's a live investigation. It's a live matter. From one week to the next, as the investigation unfolds, the circumstances of a particular matter may change.
I am aware of that. You can rest assured that I'm aware of that, because I'm aware, as we speak, that on the 4th, when he made his first appearance, amongst others, the state did not know about the information that Migrini had. So I'm with you. The point that I'm referring to is when you say an accused person must request information, and I'm saying, how does the accused know which information the state is in possession of unless the state places that on record to say, we are having here amongst the grounds upon which we would be objecting to bail, and or amongst the factors that we will be putting in. Remember, on the first appearance, the complete charge sheet wasn't there. All right? And I'm with you there because it was an ongoing investigation. All right? But I'm saying the failure of the state on the first appearance to address the court on the substantial facts upon which the state's case is based, is that not part of the problem?
No, my Lord. I don't believe that is part of the problem. The accused at the first appearance is entitled to know what he's being charged and what the reason for his detention.
Yes.
He's being told that he's been charged with, at that stage, I can't recall what exactly the charges were. But
yes,
he's been told that he's been charged with these offences, and that is the reason for his detention. That's all that the Criminal Procedure Act requires of the court, to be informed of the reason for his detention.
Yes.
That is usually done at the arrest already. But at the first appearance, the court says, all three of the court know that there's usually an inquiry as to, or the accused is usually explained you're in charge of the following offences, and would you like to apply for bail? There's never a request. On occasion, the court may decide, if the court is entertaining a bail application, may ask for the prosecutor, what are the charges the state opposing bail, and that is it. There's not a substantial summary of facts that is given to the...
But I'm saying, had that happened, all right, and that's the point I'm making, had the state stood up and said, Your Worship, as things stand, this is our information. All right? Amongst others, the accused was taken to a medical doctor preceding a confession. And this is, the state will rely on XYZ. I'm saying that address, I'm aware that as things stand, in section 6011A, it is not there. I'm aware of that. But I'm saying to you, is this not, because counsel is complaining, all right, to say information that we ought to have known about, that amongst others includes the status of our client. The state knew on the first day of appearance, and the state withheld that from us. Now I'm saying, if there was a way in which the state were to appraise the court, not to lead evidence, but at least to give the substantial facts upon which its case is relied, then I'm saying your criticism to say they must have asked for information would have made sense, because they would have known.
But is it ordinarily not the duty of counsel to consult this? Surely client will tell you, let's be commonsensical about this. Surely client will tell you, listen, I made a statement to the police, number one. Number two, listen, I was taken to the judge. Number three, listen,
Is that how far you can take the answer?
I mean, if you know that, if you've done your basic consultation with the accused. Now remember, Applicant Popo, in his examination of the accused, admits he doesn't consult the appellant with regards to the evidence. But surely not. Surely not. That is not the basic diligence that's required from counsel. If a counsel is aware at first appearance, after consulting his client, that my client made a statement, he would query the state and ask, because remember that section 335 says he has to access that.
Are you suggesting, Mr. Mafe, Mr. Minigo, that as we speak, Mr. Mafe must have known the distinction between a warning statement that an accused ordinarily makes and a confession?
Not a confession,
what,
not a warning
or what
statement.
are you saying?
I was in a room with a police official, my learned counsel. I was in a room with a police official, and they asked me questions, and I wrote down what was said. I mean, on two occasions.
But are you suggesting that there was no obligation, or there ought not to be, in a constitutional democracy, there ought not to be an obligation, at least on the state, to appraise the court of the charges and the substantial facts as part of assisting the court in understanding the charge and deciding on the further detention on the first appearance?
My lord, what is the requirement of the Criminal Procedure Act is that the accused be informed of the charges against him.
I see.
And the reasons for his detention, and be advised that he has an interest of play. And specifically, the charges have to have sufficient particularity.
I see.
And they were charges that were there. Mr. Gordler was aware of the charges at that stage because he stood up and said the accused is being charged with arson.
I see.
There's no requirement at that stage for substantial facts to be placed before the court because the state doesn't have all the facts.
I see.
Because that matter is under investigation.
Yes.
So that is not.
No, that's correct.
Now,
In fact,
section 60, sorry.
yes, I just wanted to elaborate on what my colleague is saying. In other words, you want to find out from me, is it not a shortcoming of the Criminal Procedure Act that there is no requirement?
It's not a shortcoming. The reason why is that the Constitutional Court has already looked at this.
Yes.
Has looked at section 64.
Correct.
The purpose of section 64 is first of all, is to protect the integrity of the investigation.
Yes.
We don't, at that stage, for example, in this, let's say, we don't know if there are other suspects that need to be found. We don't know what information could be important to alerting those suspects of the fact that they may be incriminated. The reason for section 64 is quite advantageous to the state because it allows us to get ahead of in our investigation and then decide what is proper to disclose. Now, section 6014 cannot operate in a vacuum because I can't come to a court on first appearance and say, Mr. Mpofu, here's my case file. That is what Section 64 is there to stop. You cannot have that case file because this matter is under investigation. You cannot have disclosure at that stage. And this is not something that needs to be argued in this court. It's been already been determined by me and in the matter of Jabala. So it's not something that I need to be arguing still at this stage of proceeding.
Thank you.
You're not entitled to any, but the prosecutor can provide those documents. And those documents were provided. Mr. Mpofu says on the, what is it? Sorry, PMs.
PM, yes.
On the PMs. Yeah, sorry, I missed it. Now I understand it.
Yeah.
But at that stage, my lord, one looks at the case of State versus Mark. The accused is in the witness box. Now let's just rewind a bit before the accused takes the stand and starts testifying. He submits an affidavit to the court. Affidavits to the court. And he says, part of my testimony that I'm going to be living for are these affidavits that I used in the High Court. And then the state pointedly asked the magistrate, my lady, or sorry, your worship at that stage, can the accused please confirm, first of all, he confirms the affidavit, and second, can this affidavit, is the accused being warned that the contents of the affidavit can be used in subsequent trial. And accused confirms, Advocate Mpofu confirms in the lower court, and this affidavit is handed in as a. Now that affidavit pointed reference to the merits of it. It describes, in the appellant's words, the circumstances of his arrest. It describes that it puts forward an alibi, all these sorts of things, and then also makes some allusion to possibly undue influence in providing self-incriminating statement. Now, what is critical about that affidavit is, number one, the state now has the opportunity to cross-examine this appellant on what he says in that affidavit. And what happens in cross-examination? He does not want to confirm his affidavit. It is the craziest thing that, sorry to use that. It is the most unusual aspect that I've ever encountered in a bail application. He fails to confirm his own affidavit. And when trying to be taken to task by putting the state's version on the merits to him, he refuses to answer any question. And State versus Mark says the state cannot be prostrate and not put the allegations in the docket to the accused. And that is what the state here does. The state says, number one, Mr. Mafe, there's video footage. There's video footage of you entering, not entering Parliament, but in Parliament, in the precinct of Parliament. And we're alleging that it's you because, number one, we see you for 30 hours walking around in Parliament, dressed in the clothing that we view on the video footage. We see you lighting papers and throwing it down into the National Assembly after you've thrown a salad and boxes. We see you going to doors in the old Assembly and throwing papers under the old Assembly doors and throwing chairs in front and throwing petrol on there and setting it up. We see that on the video footage, Mr. Mafe. What is your response to High Court? That is the response. And I'm going to explain to the court why it is relevant to look at these particular factors of how this offense was done. Because you cannot consider Section 64A without looking at the merits. You cannot consider Section 64B without considering the merits. You cannot consider Section 64E of the Criminal Procedure Act without considering the merits. So, but look, now this is the crux. Now we've dealt with Section 65 fully. So now we look at what the Constitutional Court in Germany has determined how to go about assessing and performing this value judgment on the facts before you. And it's just a weighing exercise. It's a weighing exercise between Section 64 and Section 69. And at page 27 of my report, my wasn't available. I deal specifically with the weighing exercise. At paragraph 5.118, so if the court now, first of all, in the three previous paragraphs, I deal specifically with Mr. Mpofu's arguments around exceptional circumstances. And there I argue that the magistrate was correct in finding that there were no exceptional circumstances. But then in my argument, I go further. I take the court to section 64A and attribute it or apply it with respect to the circumstances in front of this court. If you look at section 64A and you read it with section 65 of the criminal procedure, the degree, one of the factors the court needs to consider when determining whether there is a likelihood that the accused, if he or she was released on bail, will endanger the safety of the public or any particular person who will commit a Schedule 1 offense. The degree of violence towards others implicit in the charge against the accused. Now, what is the evidence that the state is going to present at the trial? The state is going to present the following evidence. The accused, in a premeditated fashion, now I'm going to put the word alleged in front and it's just going to state it as a fact at this point, but then alleged. Goes to a garage, buys petrol in a bottle, boards a taxi with in a premeditated fashion, takes a taxi into Cape Town. When he sees an opportunity to enter the parliament because of attribute to laxity on the part of those guarding parliament, he enters parliament, he goes inside parliament, he spends 30 hours inside the parliament building. So he first stops at Tainus to make sure that he can't get entry into Tainus. He doesn't succeed with entering to Tainus, he makes his way over to the old assembly, finds an entry point at the old assembly, walks through the parliament in full view of the video camera, pours petrol. First starts filing boxes and papers at the doors of the old assembly offices, makes his way to the new assembly, throws boxes and papers down into the new assembly, goes back to the old assembly, pours petrol on those things, sets it alight, goes back to the new assembly and sets it alight. And what do we have at the end of the day? A guarded parliament building.
But this
is the violence of this offense.
Yeah, just counsel. This submission, if I understand, it arises from the video footage. Is that correct? If I understand correctly, this submission that you are raising currently, it arises from the video footage. Is that correct?
It arises from the video footage, my lord. Now remember this video footage. Positive facial comparison aside.
Yes.
Person is observed inside Parliament, clearly visible. Person exits Parliament at a window.
Do we know who that person is?
My lord?
Do we know who that person is?
You know, one can only suspend
because
one's belief
it seems
for
as
so
if that
long.
was challenged, if I remember correctly, during the hearing of the bail proceedings, because that was raised at the time when an application to hand in the video footage was applied for.
Can I perhaps extend what I've said?
Yes.
The person arrested at the window of Parliament on that day he's not here, Mr. Mafe. The person arrested according to the police official, exiting the Parliament window with the stolen bag while Parliament is flaming behind him is according to the affidavits of the case docket, is Mr. Mafe, and it's pictured on video footage. The court may draw its attention to the final page of that video showing the person arrested, who is Mr. Mafe. There's no dispute from that point, being arrested at the window of Parliament. So at that point, without the facial comparison, without the fingerprints, without the cell phone evidence that has been obtained in the meantime, without all of that, there was strong circumstantial evidence at that point that Mr. Mafe was the one implicated and observed on the video.
But the contention of the appellant is to the effect that what you are postulating now is going to be heard during the trial. Currently, according to them, there is no video footage as it was excluded.
Yes, no, that's not correct. My lady reads the reasons for the exclusion was because of the presence of the still footage. And, the argument is a bit rich coming from counsel, in fact, because he argues and speculates about the admissibility of the confession and said it's unrefuted that the confession is unlawfully obtained. But that's not the evidence that's been presented in the magistrate's court. There's an affidavit from Colonel Theron where he talks about the voluntariness of that. And remember, the applicant, when given opportunity to challenge that evidence of Colonel Theron, doesn't do so. The only little bit of evidence that there is in his favor around the unconstitutionality of the confession is not confirmed by any cross-examination. It's contained in an affidavit which he refuses to confirm and cross-examine them. So how can that be taken into his favor? What weight can the court attach to that? And a lot of has been said about Mr. Mafe taking the stand. And my lady, the onus is on the appellant to place exceptional circumstances for the court. It's not for Mr. or Colonel Theron to disprove the presence of exceptional circumstances. Now, what is the value of Mr. Mafe's evidence? In terms of the state's case, no value. He doesn't answer any questions on the strength of the state's case. To make an argument that he could possibly or reasonably possibly be acquitted without him giving evidence attacking the state's case, how is that argument even logically possible? He doesn't say anything about it, except containing his affidavit, which he refuses to confirm. And in terms of allegations around the merits and the strength of the state's case, he makes no contribution. But it doesn't stop there. When the state continues to question him around aspects related to bail, specific aspects, under Section 64A, under Section 64B, he refuses to answer those questions. So what weight is not, it's the mere fact of stepping into a witness box does not give necessary weight to your evidence if you don't give evidence. He stands there and doesn't give any evidence. So what weight? Now there's an attempt at classical evidence or trying to show that the onus had shifted. But he didn't shift any onus. He didn't place any exceptional circumstances in front of him. He didn't give anything under oath to favor his bail application because he refused to answer questions from the state. So, how can you fault and find that the magistrate was wrong in finding the lack of exceptional circumstances in this instance? And you cannot find that. Then Section 65(4), then Zandile, then Portland says you cannot interfere with this decision. If you cannot find that it was wrong, you cannot find a fault in a weighing exercise, then you cannot interfere with this decision. That is the crux of Section 65(4). So, hello, my lady. I can laboriously take the court through all my arguments around every single exceptional circumstance, but I've dealt with that, and I've dealt with it with authority, with case law, and with argument, and I don't think it's necessary to go into that section because the magistrate has dealt with it also with the lack of substantial compelling circumstances. However, there's just one aspect from the previous hearing that has caused the state to mark, and that was the observation of Justice Dulari on one aspect. He spoke about unleashing the accused, and the question then arose on Section 78. You have the judgment in front of you. It's the judgment by that judgment had been out.
Yes, but we are here sitting to determine whether that decision was wrong. And this question is important, all right, in my view, to say, what is a court to do if we are saying the magistrate was wrong, all right, or she was right in leaving the question, whatever?
My Lord, what the court is saying is the following. It's faced with a certain factual matrix. Because the court is constrained by the facts of this particular matter and the record.
Yes.
But in terms of the law, the court is not constrained, but the court still needs to consider whether this magistrate applied or the lower court correctly applied the test.
Yes.
So this court's consideration is, number one, Section 6011A applied in this case. Did the applicant adduce exceptional circumstances in the interest of justice?
Yes.
And is the magistrate's value judgment based on the facts in front of him?
Yes.
The correct decision?
Yes.
So my submission is then that if one court considers the facts and weighs up the factors against and for bail, my submission is the magistrate's decision to refuse bail, not permit the release of bail, is based specifically on application of Lamini, application of the bail legislation. The position of the accused at the start of the bail application was such. After the review of the Section 78, the referral, he found himself in the position of a bail applicant with whom a presumption of his mental faculties offered him, or presumption was in his favor.
Yes.
So he was presumed at that stage, while standing in the unless the court would find otherwise, unless in a balance of probabilities otherwise, he was presumed to be having the mental faculties to proceed with his bail application. And that doesn't stop there, because if that presumption continues to offer in favor, then it's presumed that at the time that he made the confession, for example, that he signed himself a sentence. So that's the extent of the presumption.
Are you saying that this court should ignore the report by Dr. Van Tonder?
My lord, my lady, it's all I'm saying at this stage is that it's been sent back, and at some point an inquiry needs to be held once again. This bail court is not, or bail appeal court is not seized with that particular issue. Not asking the court to ignore it, but what I'm saying to the court is that there's a presumption that he's mentally fit and it's operating. So in the context of that, the court will have to divorce itself.
But doesn't that presumption operate when there is no report of a medical doctor? Because when like now, the presumption operates in my favor. But with Mr. Mafe, the position is different in that there is a diagnosis.
My Lord,
Doesn't that diagnosis tilt the scales?
My Lord, one needs to look at the paragraph 5.54 is I quote the actual presumption.
Yes.
It reads, every person is presumed not to suffer from a mental illness or intellectual disability so as not to be criminally responsible in terms of Section 7081 until the contrary is proved on a balance of probability.
Yes.
That is exactly what the reviewing court held, and it hadn't been proved on a balance of probabilities for a number of reasons.
Yes.
One, there wasn't perhaps sufficient information besides a very cryptic report from a psychiatrist. Number two, how the algorithm wasn't applied. So how can you have a balance of probabilities if you only have one side, which was established in the certificate? So on a balance of probabilities, that certificate or provisional diagnosis of Dr. Van Tonder has not shown that the accused on a balance of probabilities has a mental illness or disability. So that's a difficulty that the court and in its mind. Because now we have to assume or presume that Mr. Mafe has mental faculties and does not suffer with any mental illness until such time as on a balance of probabilities the contrary is shown. And that is not given. And it's not for the scope to consider it.
I see. Thank you.
So my Lord, I continue on page 27, dealing with Section 64A. I've dealt with the degree of violence, which one views the degree of one has consideration for the consequences, the degree of violence implicit in the offence. I deal with subfactor C, which is the intimate which is used holds against any person. That's on page 28. So paragraph C, that's contained in section 65C. My Lord, my Lady, I specifically refer to someone assist us important to open his speaking notes. No, I specifically refer to the motivation behind the commission of the offence. Now, why the motivation is important, it forms a definitional element of the terrorism charge. You cannot have a terrorism charge without an ideology or a political philosophy behind or motivating the commission of that offence. So the arson or the conduct means nothing in terms of terrorism unless you have some sort of motivation. And that's what the confession document, or perhaps the admission to be fair to Mr. Wolf, does. It establishes the motivation. But what it also does, why is it relevant for this court to determine whether the terrorism charge is supported or not? The reason is that the bail court needs to consider whether there is any resentment which the accused harbors against any person. Now, if one reads that confession document, there are aspects that are bizarre, but there are aspects that are of serious concern. He raises an intense resentment of the president of this country, of members of the provincial of the president's cabinet, and he vocalizes that in that confession. Now, where I disagree with Advocate Wolf's interpretation of the law is 217 is not the be-all and end-all confession. It is an admissibility requirements are listed in section 217 relating to a confession that was made to a peace officer needs to be reduced in writing in front of the justice of the peace. But a confession, to go back to the common law definition, is an unequivocal admission of guilt tantamount to a clear guilt. That's what our case law says. So, besides the video footage, which is incriminating, once the accused is arrested and being warned of his constitutional rights, he tells Colonel Tron that I committed it. I said part of it. That is confession. That needs to be testimony. We cannot speculate to admissibility in favor of. So that is a confession. Then from there, there's a pointing out of a petrol station where petrol is going.
Sorry to interject. Sorry. Is it really a confession or an admission?
Which one,
the one which he uttered to Colonel Tron, saying, I burnt the parliament.
No, but perhaps I should have been more. I said parliament right, and these are the reasons why he gives the reasons you'll see in Tron's. Yeah. So it's a confession on the charge of terrorism. That's what it is. And whether it's admissible or not, it's made in front of a commissioned officer and notes to take these elements from the docket that will have to be shown. From there is the point, also self-incriminating, and then the statement to Lieutenant Colonel Spahn. So that is the nexus of the state's case. It's not only about the confession. So, under C, I quote the case of State versus Yanga, and also State versus Tekeni. Although this court it's been argued in this court that one should ignore and close its eyes to a man shooting people in a stadium, what Tekeni and Yanga says that you need to consider the motivation. You need to go into the merits on these aspects of it. You need to consider. You cannot consider the violence of an offense without considering the merits. You cannot consider the resentment without considering statements which may have been made by the applicant or the applicant. Then we look at another factor, the prevalence of the offense. I'm not going to go into much detail about that. Then the fact of the matter is you have captured on video footages appellant setting this building, this beloved building of the South African people around. One cannot escape the fact that there is an element of violence being perpetrated against the South African people. Just as a South African citizen, the court is only at the benefit of still footage, but to watch this for 30 hours and then visit that building and seeing the destruction caused. It's been appealed to your emotions on the humanity of Mr. Mafe, which were rightly made, but as a South African, to see that, to watch that video footage, to witness what is the destruction caused, personally going to witness that, it's a traumatic experience for South Africans. To see it, to watch it, to see how this thing unfolds in front of your eyes and you are able to stop it. It's a traumatizing video to watch. Perhaps the magistrate was right in not watching. Then we look at section 64B, which is always emphasized as being the be-all and end-all. That is not what Dlamini is saying. Dlamini is not saying it's about flight. Dlamini is saying there can be non-trial related grounds for keeping an accused in custody. That is exactly what section 64A and E are. Non-trial related grounds. But what the state is arguing here in the case of this appellant is that there are reasons to regard him as blameless. And those reasons are captured under A and B, relating his emotional and family, community, occupational grounds. Now what Mr. Mpofu didn't quote to you further on page 85 and 76 of the record, the evidence of the applicant, was my question to him at line number 20. And I'll read. Sir, so your intention when you leave, if you leave prison, is to live on donations and the goodwill of sympathizers. Is that your plan? And his answer is yes, because there is no one that's going to employ him. So it's only the parties that are going to assist him. The court then goes further and questions him about getting firm offers of this. So this is what the appellant is telling us. Number one, I'm going to be sitting at home and I'm going to be waiting and I'm going to be living on donations from sympathizers. And then he goes up to this sympathizers as EFF, corrects himself and says the EFF plus. And the magistrate valiantly tries to come to his assistance by saying, has there been firm offers in this regard? And he says no. That is the final outcome. So this is the employment ties that we are talking about, sitting in our donations. That is what we can look forward to is that balance is released on that. Then we talk about conditions. Him staying in Mahikeng, where he cannot even afford to travel from Cape Town to Khayelitsha. There's no information, no evidence being given to support the imposition of conditions. There's nothing from family members. One would have expected either a family member to take the stand or give a statement, as the courts in status Pataka. Something to support and give the court a leeway to interrogate whether a condition can be imposed that will favor the accused attendance of court. And that, despite having the reasonable opportunity to do so, no such evidence is presented. And it's up to the court now to formulate conditions on thin air. I would submit that when one considers section 64, section 64E, related with section 64A8, capital A. Because the court in Dlamini has been very clear that this section should be reserved for instances of exceptionality. We are dealing with an instance of exceptionality here. The Parliament was destroyed in the fashion that it was, and the court thus needs to consider those factors under section 64A, capital A, which are number 1 or number 8, whether the nature of the offence, the circumstances under which the offence was committed is likely to induce a sense of shock, outrage in the community where the offence was committed. and I've argued extensively on that, whether the safety of the accused may be jeopardized by his or her release. What we see in the video footage is this accused setting, it's not only about him setting a light to Parliament, he's setting a light to Parliament while he's inside. So there is that feeling of recklessness and disregard for his own life that the court could lead into that particular factor. Then factor number D, with the sense of peace and security among members of the public will be undermined or jeopardized by the release of the accused. We can look at this incident in isolation from what is going on daily or weekly in our country. Not long before, or maybe 6 months before this particular incident, we witnessed a rampage of unprecedented attack on basically on society in KwaZulu-Natal and Gauteng. That is the context we are looking at. Daily or weekly, we are dealing with property being destroyed in the name of protest. And this cannot be looked in isolation from all the events that are taking place in our country at this time. The accused on a number of occasions indicated, or more than one occasion indicated that he intended to start the state of the nation. He didn't succeed. The state of the nation address was held in the city hall. However, that was one of the things that he indicated during his engagement with the law. My Lord, in that regard, I further support the state versus Maseru. In that instance, the Maseru judgment relates specifically to the attacks on the Golden Arrow buses during the early parts of 2000. Then, the public confidence in the criminal justice system. The public has, or expects the courts to come or to weigh up the interests of society in having public confidence in our justice system as one of the factors to consider when looking at that. Now, one has to consider, was the magistrate wrong? Has a decision eroded public confidence? My submission is that it has done exactly the opposite. It has created confidence in our justice system to deal with offenders charged with serious crimes. Now, these factors, the seriousness and the strength of the state's case are not beating that crowd. Despite our latest decision in Conradi versus the state in this division on the presumption of innocence as being a pre-trial right, as being a pre-trial and a trial right and not a pre-trial right, my submission is that even if one reads that Conradi decision, one would note that after everything Binswater has said in that particular judgment, he did not discount the fact that the presumption of innocence has a role. So, despite agreeing with his sister in KwaZulu-Natal, I believe it's maybe paragraph 20 or 21 where he says it is still a factor. However, it's not the factor, and it's not a crucial factor as being as learned Justice Nzweni indicated. It's not the crucial factor that is being put forward by the that then is section 64A, B, and E, and then the court looks at section 69, which are personal circumstances of the particular interests that the appellant has to his personal freedom, which I deal with on page 32 and has been dealt with, I believe, quite extensively by the appellant. My final submission then is that when weighing up the interests of society in section 64 with those of the liberty interests of the appellant, the magistrate's decision to magistrate's value judgment that exceptional circumstances were not present which in the interest of justice permitted the release of bail was not wrong. And if the court makes that finding, the court cannot interfere with the decision.
And just on that, did the magistrate conduct that proportionality test in terms of Section 60, subsection 9?
My Lord, if one were to draw a framework of how bail application should be done, one would look at perhaps the Solomon case, which I included, the Yanta case, which I included, and the Lamini case actually puts forward that framework. 264, 9, basically that judgment. When I considered whether the magistrate did do the weighing exercise, I looked at the judgment and saw that there were aspects of his personal circumstances that were considered out of the exceptional circumstances. So the issue of his own personal circumstances, economic loss, these sorts of things were all considered. However, not in a nice framework like I put forward to the court, or suggested to the court in my or suggested in other courts. So, my submission is, even if the court can fault this magistrate or this presiding officer with perhaps incomplete reasons, or perhaps be not applying the framework as Lamini has put forward, the finding is not wrong.
Thank you.
There's a number of aspects that I would like to reply to. In the issue of Mr. Van der Berg's work, this exact argument was tendered in front of your, page 33 was tendered in front of your brother in this division in the bail appeal. The bail pending appeal to the Supreme Court of Appeal in State versus Waka. And in that instance, the State, Mr. Van der Berg was arguing, the State, being myself, also arguing the issue of Section 64E and public interest in being not granted bail. And in the end, the State, the case of Carmichael won out against the public's interest, the public opinion on what is considered fair bail applications was in fact not to be discounted or readily discounted. So this argument of Mr. Van der Berg on page 53 has been dealt with in a bail appeal. I will get, if the court requires that judgment will be obtained, but it's Waka versus the State.
Waka versus the State.
Waka. The matter did go to the Supreme Court of Appeal, not the bail matter, but it's State versus Makala and was judgment by the Supreme Court of Appeal. Once again, the argument that Section so-called exclusionary rule against the trial matters does not find applicability in the issue of bail applications. The issue around admissibility issues has been dealt with the State versus Mampula, where exactly this argument was made. A speculation was made that the court may find that a confession would be found inadmissible, and the court found that in Mampula that speculation cannot be made, and the court cannot consider it because the State speculated in the contrary, and the court could not make a finding with respect to admissibility in bail application. My Lord, this court has been asked to look at one aspect and finding that the magistrate was wrong in that aspect, that the whole decision should be found to be wrong. My submission is the court looks at the totality of the evidence. Even in bail application, the totality of what was placed in front of the court. and from the totality of all the evidence placed before that court, the correct decision was in fact made. My lord and my lady, any other specific aspect that we should do address here?
Thank you, Counsel. We have no further questions to you. In reply, briefly, Counsel.
Take away all the dramatics and the low evidence actually given from the bar. And so this gate and all that. So if you put all that aside, which is really just evidence from the bar, you know what is the worth of that. Then what we're left with, let me just address the question that Justice Tilana was asking, which was not answered. Surely, you can't say that the purpose of section 50 bracket 6 bracket D, that's the 7-day term provision, was clearly intended to cater for a bail application, another bail application. Not this thing called, this new animal now we hear called bail information, as if it's something completely different. And that you'll get from a clear reading of section 50 bracket 6D itself, which says that the lower court before which a person is brought in terms of this subsection may postpone the bail proceedings or bail application to any date or court for a period not exceeding 7 days at a time. It's a bail application, and the purpose is the what Justice Tulare was explaining. The purpose is what we all know, that bail proceedings are not like a normal, you can't say I'm postponing sine die, for example, like we do in normal court cases. And it is, that provision is related to the one that's more well known by everyone of 48 hours, that you have to appear before 48 hours. So it's almost like an exception to that. So, okay, well, it might not be that you can get all your bail ducks in a row, so to speak, in 48 hours. So the person can appear and then you can then have the 7 days. That was the purpose. It was not meant for so-called bail information. Because then that would mean it's a never-ending rope of escaping the law. Right. Now, the other issue is a much more serious one. About information, and once again, Justice Tulare tried to probe this to no avail. If you have the first bundle, not volume 1, it's called index to the charge sheet, not the contest, but as a separate volume. In that, it should be page 56 of that bundle.
Page 56.
56, my lord.
That's the letter from Gordon Partners.
Absolutely.
Yes.
Yes, that letter provides the full answer to Justice Tularo's concerns, which is that on the 7th, remember the dates, there's the 4th and there's 11th. 7th is the date right in between. Mr. Golda, in a long 3-page letter, says effectively, give me the details of what you have, in a nutshell, and give me the details of the charges. He quotes section 35. Everyone who's arrested for allegedly committing an offense has the right at the first appearance after being arrested to be charged or be informed of the reasons for the detention to continue or to be released. And then he goes on and so on. And the paragraph 8 says, it is our submission that Mr. Mafe's constitutional right to be informed of the reasons for his further detention has been grossly violated. Now, the simple issue that was being raised by Justice Tularo is that at that point, and my learned friend liberally says that we don't accuse them of malafidus. Well, he's wrong, we do. As Justice Tularo pointed out to him. If we're saying that they ambushed us so many times, there's no such thing as a bona fide ambush. So this is the exact point that Justice Tularo was trying to get a response from. You know, you are the state. You know that the person has done a so-called confession. But more importantly, you know that they've been diagnosed as schizophrenic. This you know. How can you say the duty was on Mr. Gorda to say what? Has the accused not been diagnosed with schizophrenia? Who does that? Because that's not the normal, it's for the state, and as was being, the ethical duty upon the prosecution is to say, look, there's a confession and there's a diagnosis on the 4th. Because all these things have happened in the day. But let's forgive them. Let's say for some reason they forgot or whatever, for some bona fide reason on the 4th. On the 7th, they get this letter from Mr. Gordon, pleading and threatening and doing all sorts of things. Say, give me what you have, as I've summarized it. They don't respond. The 8th, the 9th, the 10th. On the 11th, I'm flown from Johannesburg to come here to do a bail application. Not to listen to bail information, whatever that means. To do a bail application. Mind you, that bail application is on a Schedule 1 offense, because that's the information Mr. God has knowledge. Except, of course, the rest I've already said. When I get there in the morning, 10-15 minutes before we start, here's the certificate, terrorism. So we're moving away now from Schedule 1. And we've been preparing since the 4th to the 11th on the basis that we have a Schedule 1 offense. In court, we're told, no, it's a Schedule 6. Here's the certificate now. Okay. Okay, fine. We'll still have the bail application. Oh, by the way, here's a diagnosis for schizophrenia, which has been with us since the 3rd, which we have not given you on the 4th, on the 7th, when the letter came, or yesterday, on the 10th, but we're giving you to right now in court. How can that be bona fide? That's the ambush we're talking about, the continuous ambush, which has to be deliberate. There's no way that somebody didn't think that this medical information was important. And there's no way that nobody thought when the certificate came from the DPP about the new charge, it should not be faxed or something made to Mr. God. No, the intention was clearly to do exactly what happened, to induce a further postponement, except that we said no. we're not going to do that. We went the bail application, and then there was the illegal section 78. I made this very clear. I'm not going to go back because of time. Section 78 has no application to this matter. And I explained this before. I don't know how we degenerated back into that issue. Section 78 is about the mental capacity of a person to commit an offense. It's got nothing to do with what we are busy with here. Section 77 applies to this situation. So, in other words, as we all know, you might have a mental incapacity which is relevant to the question of the confession, because at that time they are not in a sober sense. Let's say I'm taken for a confession a week after I've been arrested. And at that time, I'm traumatized by whatever has traumatized me inside the prison. Then the confession will be inadmissible for that fact that a week later I was traumatized by something I saw in prison. That has absolutely nothing to do with whether at the time of the commission of the offense I was in my sober senses, which is the province of Section 78. So that confusion, I don't know how it has crept back into this matter. The only issue we make about the Section 78 issue is that it does not lie in the mouth of the same state. And one doesn't need Section 217 or anything to understand. It cannot lie in the mouth of the same state that is saying, I'm not in my sober senses on the same day, and then take me to do a confession on the same day. That's really the only point we're making. And therefore, if you go to paragraph 20, I think that's volume 4, and we go to Tehran's so-called affidavit.
What page is that?
It's 7, paginated 7. That would be paragraph 25.2 of his affidavit.
We are with you?
Yes. Thank you.
Yes. Thank you very much. Okay, now I want to read the whole thing. 25.2 says the applicant appears in the confession. Let me just stop there. My learned friend now tells me that no, they didn't really, when they say confession, they don't really mean confession. They mean whatever they say. No, we know what a confession is, and it's regulated by Section 217 of the
CPA.
CPA, yes. And sorry, let me finish this. I'll come back to it. And then he says whatever, the confession and so on. This beliefs and justification for his actions are laid to whoever making to the subject to public officials. Then just jump to 25.4. There is a medical report from a doctor who made a provisional diagnosis that the applicant suffers from paranoid delusions and may be paranoid schizophrenia. So the same gentleman, under oath, in the ambushed affidavit, makes totally mutually exclusive statements in the context that I've described earlier. Because he says there's a confession, and then literally 2 sub-paragraphs later, it says the person is non-compos mentis. So that's what you are dealing with here. Yes, the question of serious charges, please, has never been misunderstood. We said it before the United Nations, which charges are serious. Who can say that the charges are not serious? So we don't need all that dramatization. It's common code that the judge has said as hence we are on the hands. And we simply complain about the ambush. Yes, the point that I was over eager to make was because my learned friend in the same breath as saying something about the confession which I don't understand, also says that the Rule 35.5 has no place in this. Well, if you go to George, at page 24-53, you'll be surprised to learn that the court says this, the learned court says this. I'll read two paragraphs so that I kill two birds with one stone. So it is thus clear that in respect of crimes which require mens rea, an admission of the actus reus will not normally amount to a confession, no matter how prejudicial such admission appears to be. Thus, an admission such as I killed X will not be a confession, whereas I murdered X will constitute a confession, as murder is a technical term relating to the intentional and wrongful killing of a human being. I'm just making that point cross reference. I want to explain that I explained it in chief. But here's the important part. Just in that same breath, it then says, the fact that such defenses would be hopeless in the light of the circumstances to which the police would testify does not provide the missing elements in the statement so as to make it a confession. In other words, even if it's a palpably hopeless defense, the mere fact, the absence is in the negative, the absence of a confession on mens rea, for example, would be sufficient. But I'm linking that to page 24-56B-2 of tutorial, where the learned authors then make the linkage I was making between 35.5 and confessions, and emphasize the point that this is not about, this got nothing to do with only trials, it's not confined to trials. It says giving teeth to these and other constitutional rights is section 35.5, which provides that, quote, evidence obtained in a manner which violates any right in the Bill of Rights must be excluded if the admission of that evidence would render the trial unfair. And that's the problem. People always stop reading there. And it would render the trial unfair or otherwise be detrimental to the administration of justice. And that's, I'm arguing this case on the basis of that second level. I'm saying it would be detrimental to the administration of justice to give, if any, effect to this so-called confession, given all the things we've discussed earlier about the state of mind, the involuntariness, and the fact that, after all, it's not a confession. So that's the context in which we raise that. Look, the simplest way, really, to articulate my case is as follows, when now it comes to the wrongness test. I can articulate it by asking a rhetorical question. How can it be if the learned magistrate based her what I call the main grounded, her main allegation, her main finding on the issue of the so-called propensity and the hammer strike and all that. If those bases factually are wrong, then how can the judgment not be wrong? The answer to that should be obvious, that if the factual basis for those findings, for the key finding, which underpins the judgment is based on the wrong premises, then obviously the judgment is wrong for that reason alone. So that's really, in a nutshell, if you cut out all the of course you need the constitutional context and so on and so on. But that's how can this court say, no, we agree with this notion that there's a document where he said he's going to do it again. Or we agree with this notion that there's or rather, the hammer strike proves how bloodthirsty he is. Because those are just wrong factually, just simple wrong. And therefore, and then they give rise, as I say, to the thing about the public and product. So, I want to respond to the issues about basic diligence of being a Sangoma and knowing that there's some Fantanda. I don't think even I can have those problems. Yes, just as a matter of interest, I just referred you to that 25.2. If you go to paragraph 29 of Mr. Teron's affidavit, paragraph 29 says the video footage will be sent for enhancement and for further facial comparison analysis. I made that point earlier. I'm just simply flagging it out for as a matter of interest. Because I even answered that without reference to this. Like obviously those are issues that will be dealt with at the trial. So if he himself, forget the fact that he dodged cross-examination. I mean, my learned friend criticizes Mr. Mafe for refusing to answer questions about the merits for explicable reasons. But Mr. Mafe was there. He testified and he was cross-examined rigorously by my learned friend. But the same learned friend of mine wants this court to take into account an affidavit, an ambush affidavit, where its maker, who was present in court, was hiding behind the affidavit and did not want to be cross-examined. You know? And now we hear something, I don't even know what to call it. Oh yes, this is the version of my learned friend of what a confession is. He says, no, the accused person told Lieutenant Teron something. Lieutenant Teron then put it in an affidavit which was not authenticated or confirmed by anybody under NO. I mean, that's not even hearsay, I don't know what to call it. And so all that, we must take it as a confession on the common law or whatever basis my friend has to come. I've never heard of such a thing. It's just a mumbo jumbo of a hearsay over hearsay over hearsay that is not, and then it's not tested by anybody. Compare that to a man who says, I'm here, I'm going to speak, and you must cross-examine me, and I will deal with the issues. Yes, of course, we know about the onus, but the onus doesn't mean we throw away all the rules of logic, and we don't say to the... And if all the rules of evidence were thrown away in bail applications, then why do we talk about the onus? The onus is a rule of evidence. So it just shows you that though not all the rules are thrown away, But of course, it's sui generis and its rules are applied in a particular manner. But we must not go to extremes. Yes, those are our submissions, but it really boils down to we're indebted to the court for the time. This matter does present certain complexities, but we urge the court with the greatest respect to reduce it to its bare bones, which are, as against all these constitutional rights that we've spoken about, as against what is said, and whatever the case is, as versus Waka, that case was, the paragraph I quoted in section 33 was not so much for the public comment, it was for the fact that the author says that detention without trial and pre-trial detention are inseparable. That was the real reason I was going to proceed. And I don't think that was dealt with in us versus Waka. Now, in all those advantages, as I say, the accused goes to the game with all these advantages packed in his favor. As against that, as against the evidence, the real evidence that was before the court, which was from him, as against the fact that such counter-evidence, quote-unquote, as might have been, had come in these unacceptable ways of ambush, active concealment. Because that's really what we're accusing, in case there's an ambiguity, that's what we're accusing them of a malafide active concealment of essential documents, which is even worse than normal malafides. Against all that, against a confession, quote-unquote, that's not worth the paper it's written on, against the fact that we have a collection of exceptional circumstances, and I'm prepared to concede to say that it may well be, just for the purposes of progress, it may well be that each of those concessions, of those circumstances viewed in isolation is ordinary. But our law says that once you put those ordinary circumstances together, they may amount to exceptionality. And that is the law that I implore this court to take. And that against all those, the question must be asked whether to use the text, we agree on something, my learned friend and I, which is paragraph 13 of zoning. Whether then the factors that were taken into account for and against granting of bail should lead this court to the conclusion that that judgment was wrong. And in our respectful submission, it was. Paragraph 14 of zone that my learned friend was saying I didn't read, doesn't say anything worse than that. It actually is a further contextualization of that proposition, namely that this court may impose itself, for lack of a better word, into and pretend to be sitting as the bail application court in certain circumstances where this test has not been passed. In other words, where the factors for and against weigh in favor of wrongness, so to speak. That's all. And that, I'm afraid, is all that this court has to do. In those circumstances, we implore and beg this court to look at this matter dispassionately, apply the law dispassionately, apply the Constitution dispassionately, and there can only be one outcome if that is done. If we leave out all the drama and simply look at the matter as it is, look at the record as it is, look at the reasoning of the learned magistrate as it is, we can only come with one outcome. But this is a case which cries out for the application of our Constitution and the proper application of Section 60 as court was.
Thank you, thank you.
I to the court for not taking even a short comfort break.
Thank you, thank you. Yes, did you see what?
No, sorry, maybe I'm preempting whatever the judges were talking about. But I'm sorry, my instructions were to just, without putting any pressure, just to say that we know that this matter involves a whole lot of facts and so on. That if it is at all humanly possible, at whatever stage, that even without the reasons which may follow, that as soon as it is possible, because the person is actually sitting in jail. I know that the judges are very sensitive to that, but I was told that at some stage I should just throw that in to say that if judgment is going to be reserved, then hopefully, even if what the judge president called an academically reportable judgment may come later. But we at least pay some attention to the fact that the person has been sitting in jail for 5 months. And I know I'm preaching to the converted because the mere fact that this court has convened in such a short space of time means that the court is sensitive. But it's not just my instructions to
Thank you, thank you. Okay, thank you very much to both counsels. I must say that this has been a very complex matter, and we're very much thankful for the insightful argument. As it has already been said, this matter has been pending in this court for a very long time. We said we listened to the matter on the 25th of April. Here we are again. We're still listening to this matter once again. We are of the view that at some point this matter needs to reach its final conclusion, and we are going to adjourn at this time. We're going to deliberate with my colleagues. We'll come back at 3 o'clock to give judgment in this matter. I'm sorry I didn't come back to you.
I'll try and maybe get a colleague to come because I'm flying to a place.
Are you not booked to be with us today?
I know I'm actually on leave today. I was due to leave for a foreign destination at 3 o'clock.
It's fine.
Yeah, you can get somebody to stand in for you because, as I said, the matter has been pending for quite a long time. And
I understand, so that is why I sacrificed today.
No, thank you very much for that. Thank you for ensuring that at least you avail yourself to come and argue the matter. Thank you very much. We are going to adjourn and we'll resume at 3 o'clock. And this court will adjourn.